The 17th International Congress on Human Rights is organized by the postgraduate program on human rights provisions. It's organized by the Tocantins state and organized by the Magistrate School and the Federal University of Tocantins for over a decade. We've been partners in perfecting instruments, justice instruments. The Congress has as a goal promoting the interchange in practices that are geared towards the protection and guarantees of human rights, as well as increased effectiveness of the judicial branch. In this edition, the Congress would like to honor the Portuguese magistrates, Igreja Matos, Nuno Miguel, and Moras Lopes, and counts on the participation of speakers coming from Brazil, the United States, Morocco, and Portugal. The subject is the state of unconstitutional issues. That's the theme. And with this, we start the third and last day of the 17th International Congress of Human Rights. Welcome, everyone, once again. Let's start now with the think tank activities. The think tank format is geared towards stimulating an interchange of ideas where experts will be presenting analyses on legal issues faced by the countries and the possible legal and institutional reforms that are possible in addition to theoretical arguments. We hope that this Congress will provide practical solutions and justice. We would like to invite at this very moment the mediator, Liziane Oliveira, Dr. Liziane Oliveira. Thank you. We'd also like to invite the debaters. José, we'd also like to invite Appellate Court Judge Igreja Matos, Dr. Lauro Ishikawa, Dr. Thiago Matsushita, Judge Helvia Tulia, Masters, the Glacielle, Torquato, and Nayana Guimarães. I'd now like to yield the word to the mediator and the coordinator. Good morning, everyone. It's an honor to be here at the Tocantins State Court in this event organized by ISMAT. And as the professor of the school and researcher in human rights, it's a pleasure to lead this mediation of this panel with colleagues, with new friends, and people who I've known for quite some time, such as Glacielle, which is a PhD student right now. The goal of the think tank is to think about the quality of the experts, and it's about thinking about how our legal instruments are being incorporated in institutes that we've imported from Colombia, but that we've been using even more so than the Colombian courts. Looking at our audience, I can see that composed mostly of young individuals. The first question to ask is, do we know what the state of unconstitutional issues is, or an unconstitutional state of issues, as Appellate Court Judge Igreja has mentioned? Do you guys know what that is? This is what we will be knowing in this panel and trying to reflect together. What is this institute? Its legal nature. Does it exist in the Portuguese system, the European system? So I'd now like to yield the word to Appellate Court Judge José Manuel Igreja Matos to comment on the Portuguese system, the European system, and to know if in this system there is this kind of system. Good morning to everyone. I would like to congratulate you for being here and at such an early hour, which allows us to share some of these knowledge and experiences with you. When asked to speak about this subject regarding European issues and what occurs in Portugal. I thought about thinking about an explanation. I'd like to start with Aristotle. Aristotle used to say that there are three ways of convincing an audience. There are three ways of arguing or provide arguments in the auditorium. There are three: ethos, pathos, and logos. Ethos is about the credibility of the person who is transmitting the message. Ethos is perhaps at its origin my invite to be here. Perhaps you guys wanted international jurists here, but I will not be using the argument of the ethos. And then, which would most impress the audience, is the pathos, to try to convince the auditorium using rhetoric, using the exercise of visualizations, trying to have an almost irrational manner of trying to convince. And then finally logos, which is about the facts, which is about the logic, which is about objective explaining of what occurs. This subject, this year, for this subject in Europe, we do not have pathos. We don't have beautiful stories to recount on agreements, sentences, decisions, on the state of unconstitutional issues. There's no way. Over here I cannot transmit something because at this moment we have no decision that will allow the European Court of Justice. We don't have anything at a European or Portuguese level where the subject is this, specifically this one. But despite everything, we have been, not everything is negative. I could provide recourse to the arguments that come from the logos, from logic, and recount some facts, some concrete situations where this issue, though not directly present perhaps, it's not something that's palpable. We haven't found any decisions on it. But even so, it's implicitly or indirectly it's implicitly and indirectly present in current affairs. We have the environmental issues, we have the prisoner issue, the health issue, regarding the pandemic as well, or COVID and its human rights and fundamental rights, education, lack of public education. These are 5 items from which we could venture ourselves to discuss something that remotely is connected to the state of unconstitutional issues in Europe. Of these 5, let me choose a sixth issue to add to the 5, and that's about the crisis of the rule of law. What occurs? Quickly, let me not belabor this point, although if necessary I can, but the European Union has been through a crisis period regarding the affirmation of the rule of law. We have 2 countries, Poland and Hungary. Because of elections lately, the parties that ascended to power undertook reforms that in the European Court of Justice Tribunal, the Article 2 of the founding treaty speaks exactly to the fact that we are part of a union, and it is necessary for this to have the rule of law for all member countries. We have to have all of the instruments, non-discrimination of minorities, for example, independent media. That's also very important. And in light of this scenario where we have 2 countries, Hungary and Poland, that because of right-wing and extremist right-wing parties, the fact that they were elected, they started to put into doubt the application of the rule of law. And the tribunal of the European Court had a decision, a seminal decision, which was a 2018 agreement, exactly on an issue where the Portuguese judges also participated in. And this association of Portuguese judges poses question to the European Union courts. The European Court issued an agreement, cited hundreds of times on this issue, and the European Court explained 4 or 5 criteria that would establish the rule of law in the world of the tribunals. And from this agreement in 2018, because the tribunal issued very detailed and concrete decisions, what are the limits of the rule of law, or what are the... and because of this decision, new issues cropped up regarding Poland and Hungary, where the tribunal, the European Tribunal, was concluding in various different decisions, and they were concluding that there were systematic issues and problems, and structural problems, systemic problems on the reform of the judicial branch, the approval of laws that created councils because of political, with right-leaning political leanings. They were manipulating the power, the party in power was issuing new guidelines to the judges, and they were by themselves a stranger to the tribunal, which was a council that were put into power by the right-wing government. So we had reforms, not only that led to the conclusions, not myself only, but of the European courts, that there was a systemic, a structural problem, a problem where the roots themselves of what the European Union, the project is, and I had the tribunal reaching a decision where this systemic problem was existing, and that care should be taken in relationship with countries such as Hungary and Poland. How did this become a concrete reality eventually? In the issue of the European mandate, we have a system in Europe where within the European Union, if a citizen is detained, for example, if a Polish citizen is detained in Portugal, the system, if Poland solicits that this Polish detainee be remanded back to the origin, to the country of origin, there's a relatively simple system. We all belong to the same structure of the European Union. We send this detainee back to his country. This works in a daily manner. It's a common act in the European Union tribunals, and the national states do not clash with the situation unless it is concluded, exactly in the case of Poland, that there was a systemic problem, which was also structural, where it's in question if we have a state of unconstitutional issues there, and that would justify that the national judge would decree, for example, in Portugal, the non-extradition of that citizen, because if he were to be extradited to Poland, he would have been judged by a tribunal which would not be impartial, not independent, that would be controlled politically. And this occurred, by the way. The most emblematic case, best known case, is a case of a citizen called Mr. Selmer against Poland, and the decision was reached by an Irish judge. The Irish judge, in light of the situation and in agreement with the decisions of European Union courts that had declared that there was a systemic and structural problem in Poland regarding its rule of law, so this Irish judge understood that it would have been at least questionable or even dangerous, or not recommended to have that citizen be remanded back to the court of origin. In this case, Poland. And the Irish judge, you may know, this Irish judge used a mechanism. Using a mechanism, she requested information from the European Court if she should send that man to that country. And the European Union Court created what is called the Selmer test, which basically include two criteria. The first one, the national judge, the Irish or the Portuguese judge or the Spanish or the French judge, they must ask themselves, this country where I will be extraditing this citizen to, does it have a systemic and structural problem regarding the rule of law? Yes or no? If the answer is yes, and in the case of Poland and Hungary, it's an almost inevitable decision, then there would be a second criterion, and this second criterion became a matter of controversy that created huge problems, and that is if this is systemic or structural problem, would it lead to a concrete result where that citizen, for example, Mr. Selmer, if we admit the existence of a structural problem, would this structural problem, would it materially affect and would it harm that process where that individual was involved? And yes, we could reach a decision, yes, that there is a systemic problem, but in this case, it wouldn't really be relevant. Or, yes, because this independent judge could never judge, and a non-independent and a partial judge could not really judge. But so the tribunal asked the national judge to have this checklist and verification of these two criteria, and that was it. And we are in front of us of a subject that should be labeled a crisis because of a systemic problem. It would be the state of unconstitutional issues. It afflicted and it still afflicts the EU, the European Union. But the happy ending is that the first party that in Poland created this system, they lost the elections last year in 2023, and it was replaced by another government that at this very moment is dismantling all of those laws that actually put into question the rule of law. In Poland, for the time being, we do know that things are not easy regarding the wind of the populist problems. But for now, the situation in Poland is much better. In Hungary, the situation is certainly not improved. Thank you, Ms. Appellate Court Judge, for your words and your comments, and to clear up how things have been occurring in Europe, in the European tribunals. So now I'd like to yield the word to Dr. Of the Tocantins State Courts, Dr. Helvia, Appellate Court Judge Helvia Tulia. Thank you. Thank you, everyone. I'd like to thank you for the invite to speak about the state of unconstitutional issues. When I received this invite that came to me forwarded by Ismat, I started researching the subject, and we were talking about this Appellate Court Judge Igreja Matos. Perhaps in Europe right now, there is a crisis in the rule of law, a possibility of an existence of this state of unconstitutional issues. In Brazil, we have different ADPFs that question this state of unconstitutional issues. So now we would like to appeal to the facts, to the logic, and I have the pleasure. I will try to cite some of these situations and mention one where we have public policies that are geared to the situation. We have structuring policies, and the question is, why is it that the state of issues in this manner, why does it not transform itself? Why does it not change itself? Let me seek some information here in my notes. We have here in the Supreme Court the first one, which is decision 347 regarding inhumane treatment in prisons in Brazil, 770 about the illegal deforestation of the Amazon forest. We have decision 918, which was advocated by the Brazil's Bar Association, that requires the recognition of the state of unconstitutional issues regarding cultural policies. And we have the ADPF regarding structural issues regarding racism, and that's a decision 973. We also have decision 976 proposed by the Sustainability Network regarding the state of unconstitutional issues of the homeless population, and one proposed by Brazil's Advocate General, which questions the taxing of ICMS taxes regarding fuels. And in this DPF, what is really striking about this decision is that there was an agreement between the federal branch and the states about the taxing of ICMS. And in Marco Antony's opening comments, he mentioned this issue about the violence against women. And if we work in the courts, we coexist very closely with this. As judge, I worked in family court, and I can see that there's gender violence in all its different forms. I've been seeing this for a long time. And now, to taking advantage of the comments of Professor Nuno, as I am not empowered, I may not have the gift of bringing here some issues that may strike the audience by maybe some story counting. So therefore, I am referring to the facts here in Brazil, and my thoughts here regard gender violence. Would we not be right now facing a state of unconstitutional issues if we have gender violence, despite the Maria da Penha legislation being approved? If we have a structural situation, should we not seek perhaps other issues, other structural policies that could in some manner overcome this practice that is common in our day-to-day life? We've had in Brazil in 2023 1,467 cases of violence against women, women-related deaths. We had 2,000 cases of domestic violence. We had an increase of 9.8% regarding the previous year. We've had 778,000 cases of threats issued. At each 24 hours, 8 women are victims of domestic violence.
And these are figures having to do only with household violence. The Institute of Statistics does the map of violence in 2023. It featured the figures for the past decade, 2011, 2021, 49,005 cases of women were murdered in Tocantins. According to the Department of Public Security, we had now in 2024, we've had till August, 8,547 cases of home violence, according to Maria da Penha legislation. 2,362 cases were in Palmas, Mutes, 1,300 in Araguaína, 487 in Gurupi, and 450 in Porto Nacional. And that's when I ask myself, are we faced with a state of unconstitutional things? Faced with figures that never go down. Every year they keep increasing, rather. So wouldn't we be faced with a state of unconstitutional things or matters? I'd like to give you this as food for thought. We do have public policies. We have a piece of legislation that's recognized as one of the best laws when it comes to protecting women. And how come this law does not produce the effectiveness that we hope to get out of it? Because we don't have, when it comes to this normative, the effectiveness that we were seeking, because the state of unconstitutional things is not only in the inertia of the state when it comes to issuing laws, it is mostly related to the effectiveness of public policies. That is, it's not enough to have a public policy. I need to make sure this public policy is effective and produces results. My talk here on this panel is to bring you a reflection. We, as legal actors and agents and social actors, are we doing, or do we need to do, what do we need to do in order to leave this state of unconstitutional things that we have vis-a-vis violence against women? I see here judges, colleagues in the audience. We know that our where we work, most of the situations of flagrant crimes have to do with violence against women. We were surprised when a shift goes by without any cases of violence against women. We should actually work out the statistics for those shifts where there's no violence against women. I was talking with a colleague, and he was surprised because on Monday in a whole month, he didn't have to issue a decision of protective measures related to a case of violence against women. So we need more than the Maria da Penha legislation, which is laudable. We mostly need to change the culture that may establish gender equality, and that is not done without education. Without massive investments in education, so we may transform the view that people have about females in general. The structural chauvinism doesn't do harm only to women. It does a great deal of harm to society overall and to men themselves and all of us. All the men and women that live in the society, we stand to lose. My reflection at this point, even though we're debating these things, I think that has to do with a state of rule of law, where we have a rule of law in which political, social, and economic equality is not ensured to all the men and women that live in the society. The reflection I'd like to put to you, and now going into the code itself, the law code itself, the state of unconstitutional things, is it a measure that can only be done at the level of at the Supreme Court, or could it be that the states, under peculiar situations, peculiar to each federative unit, they would be able to, and I'd like to put this discussion to your attention, would there be mechanisms that these units, federative units, could rely on and recognize in each particular state, a state of unconstitutional things? Or would it be possible only to do this put this argument before the Supreme Court and issues that have an impact on a nationwide impact? Thank you. I would like to thank Dr. Tulia. And now I will give the floor to Professor Dr. Lauro Ishikawa for his remarks. Good morning, everyone, ladies and gentlemen. First of all, I'd like to record a note of thanks to the School of Magistrates, especially Appellate Judge Marco Villas-Boas, for the invitation to speak to you today and the warm welcome that I've been accorded, always very brotherly feelings that flow around this event as a professor and as a participant in academia. This is one of the schools, it's actually a benchmark from the schools that we've been following up on from Sao Paulo. As a government school and is a state court school. We're in the midst of legal experts and international guests who came directly to this Congress. This participation obviously turns these topics, in fact, into something really relevant, given their importance. I would like to give you a few words related to a problem, and through an analogy, I would like to introduce the issue of the state of unconstitutional things as an institute that we have imported from the Colombian state court, upper court. And my beginning then for this attempt at an analogy, we're going to go a bit beyond to get to Brazil, and it's a matter of perception when it comes to these large, complex topics. I would like to begin with a small anecdote that took place starting in the Stockholm Conference in 1972 when the debate began about protection of the environment. There was a conference about the environment in 1972, and starting at that point, environmental affairs became more relevant worldwide. We have had an attempt to define what it meant, sustainable development, what it actually meant, and that happened in 1987 only, in 1987. And there was general criticism on the reason why these topics were awarded so much significance, sustainable development, if only social, economic, and ecological issues were on the agenda. In 2014, the United Nations issued criticism, and brought a solution. What was missing in that concept? We were missing the dimension of governance. And the summer school that we had recently in July 2024, and at the Siena University, Professor Tanya Grupp, who shared with me a roundtable discussion, a thematic roundtable. She ran a catalog of all of the countries that have sustainability written in their constitution. I didn't see here in the federal constitution of Brazil, I didn't see it here. And in a quick answer, I said, well, that's because in reality, it's written in a different way in the constitutional text, but not exactly with this kind of phraseology. The biggest criticism that people have made, and that's why I would like to bring you this analogy on the vis-a-vis the state of unconstitutional matters. A professor under Professor Matsushita's invitation, he was in Brazil 11 years ago, Professor Jorge Benoales, he says that this is a trick, diplomatic trick, to place certain subjects to bring everybody around the same table, and they leave that table as if they had indeed adopted those large themes and assumed a commitment. So what would this diplomatic trick amount to, this diplomatic trap, if you will? If I write in a few words, people won't sit around the same table. A word governance will come later. Why is it important? Because, and now quoting Nalberto Bob, the rights have already been written and foreseen and assumed by all the nations. What's missing is the implementation of these rights. Governance comes with this weight of responsibility in as if there were the possibility to create a metrics, certain metrics to observe, to know, to ascertain whether those topics are being adhered to or not. Now, listening to our dear judge who spoke before me, the rights are written. they've been internalized. The Maria da Penha legislation came within a context of former negligence because of an imposition by world order. And today we're still going through these big problems, and that is, it's a question of metrics, dear Excellency. If we are to really pay attention to the cases that are not seen as female murder, or they're not framed as female murder, the figure goes up. I mean, it's a lot bigger, it's a lot higher. When we brought this institute of the State of Unconstitutional Affairs, the defense made by Professor Daniel Sarmento and this ADPF 347, if I'm not mistaken. In fact, we have inserted both in the doctrine and now in the jurisprudence the state of unconstitutional matters, and that was recognized as such. Professor Andre Ramos Tavares, president of the Electoral Court, professor, the full professor at USP and FADISP, he says that the state court system, and it doesn't have to do with the state of constitutional affairs, but he says there is a crisis, and this crisis goes through three phases. The first one of them is the crisis of numbers, figures. 10 years ago, Minister Ricardo Lewandowski, in a lecture he gave us at FADISP, he said, we've gone to 100 million lawsuits. And that means that 1 in every 2 Brazilians has filed a lawsuit. It means that all Brazilians, and they're all fighting against each other in the legal court system, if they're defendants or plaintiffs. The crisis starting in 2015, the Supreme Court has enlarged the role of responsibilities when it comes to lawsuits that get to the STF for judgment. The second crisis that Professor Andre Ramos Tavares has drawn our attention to is the crisis of limitations. He calls them complex cases. Many of them involve moral issues that are placed on the agenda of the Supreme Court. Among them, so many of them, we may cite, for example, we may quote recent decisions, for example, homosexual relationships, and now this it's been recognized as a state of unconstitutional affairs, which is the crisis of penitentiaries and the penal system in Brazil. And the Supreme Court has decided, the Supreme Court has decided, therefore there is a crisis on the limits that brings its own consequences. Well, one of them is exactly what Professor Andre Ramos Tavares has called a blacklist, and the decisions that are taken which receive aversion. They are the object of aversion, immediate aversion, by some interest groups that start disseminating to the whole society instantaneously, instantly. In the afternoon, we're going to have a panel on artificial intelligence, and I'm sure, absolutely sure, that will be on the radar, the speed at which we follow decisions by the Supreme Court. And a third crisis is the crisis of identity, and this identity crisis flows from the decisions that are taken by a minister, and decisions that would be collegiate decisions, but they're made monocratically by just one minister. And that obviously brings its own consequences, a response, a reply, be it from the executive or the legislative branch or interest groups. An example is a minister of the Supreme Court issued a prison sentence against the president of the Federal Senate. a minister saw fit to issue, to state that a politician that is the defendant in a lawsuit cannot actually be to hold a position of legislators. So that aversion has become quite popular, and to bring the feeling of these crises that Professor Andre Ramos Tavares has drawn our attention to, multiple crises on this specific topic of the state of affairs and constitutional affairs. Beyond those issues that our dear judge has alluded to, there are other cases that implicitly are treated or dealing with a state of unconstitutional matters, but expressly they won't be mentioned.
An example is the lethality of police action in Rio de Janeiro slums. And this has also, even if it was not expressly referenced as a state of unconstitutional issues, this calls attention the fact that they're using helicopters to bring down citizens, and this was shown on TV, not to suppress or to say that it's not possible, but just to explain and justify the why these helicopters were used and these means were used, if would there not be another solution. Therefore, because of these crises, or starting from these crises and these identifications, Brazil's federal Senate has determined the establishment of a committee composed of law professionals to have a new legislative proposal on a structural process, which is being debated in the National Justice Council. It's being also discussed in the Senate, and this should have society step up to the debate, because public consultations are still open. And one of them, Cynthia Brunet, a federal judge, who is a professor at our institution, she mentions this a situation that could exist if the legislative proposal could be approved of the structural process. What if the magistrate refuses to explain that could be refused, that is a structural issue? What if the judge refuses that? Then we are, again, that can be appealed, obviously, but why are we regulating something that is already generically is available at the Civil Process Code? So why not have the possible solutions? It seemed relatively sensible of the comments were sensible that came from Cynthia Brunetta, that if the magistrate is not convinced that certain case could be considered a structural process, then the judge should call the parties and hear from them, because that would be something that would be normal in a court case that is very complex, such as this one. Why? Because the judge would bring to itself and to its courthouse a problem. And in this legislative proposal, there is a provision where the judge can act upon these court cases that are pending in its own courthouse. So that judge could deal with these structural projects or processes that start in its own courthouse. Everything that is, some people say that everything that is new takes time to read. Here, we're not just talking about new things, but about proposals that are ongoing. And there really is an attempt of not only putting these things on paper, but also create a KPI which will control or measure the verification of its implementation. And in this DPF 347, in this process, the following step has been given. There is a plan already. It is already officially linked to. It is linked to this issue. Civil society is participating already, and it is about taking on responsibility so that this decision is effectively complied with. And that's my initial comment. We are now discussing, we've been discussing for more than 50 years the environmental issue. Nowadays, we already have a new DPF of the burnings. We have Supreme Court justices saying that you have so many, for example, you have so many days to present a plan to increase the number of firemen in such in determined locations. And the Professor Tavares foresaw this a long time ago when he wrote a manual on the court system, on the judicial branch. He had been observing this already. Regarding this mandate of the court system for certain issues and certain themes, but in fact it is impossible to understand this in a negative context. Certain decisions that are reached by the judicial branch, by the court, especially the Federal Supreme Court, when we talk about regulation issues. Which is why this professor mentions as an activist mentality, as an obligation regarding that specific subject. Of course, we cannot allow that everything that is environmental, then we must have that understood as a state of unconstitutional issues, because that would make the institute, that would reduce the importance of the institute, that would make it banal, if you will. But the current Supreme Court Justice, Minister Dias-Toffoli, says that if human activity is a response to everything, then it belongs to nothing. It's about prioritizing, and you cannot solve everything. So we are not here talking about something simple. But the fact is, at least this example that came from the Colombian courts brings us this consequence of a decision not being given only by an organ or an agency of these three branches, but a plan for implementation as well. Thank you. Thank you, Professor Mauro. We have quite a few issues to improve our debate. I'd like to remind you that you can send written questions, or you can scan the QR code. If it hasn't shown up yet, it will be made available shortly. There it is. And you can ask questions. But to continue with the comments of our colleagues, I'd like to yield the word to Professor Glacielle, who's also a court servant, for her comments. Thank you, Professor Liziane. Good morning, everyone. At this first moment, I'd like to thank the Magistrate School for the opportunity of participating in this debate with this wonderful group of experts, professionals. I'm very glad to be here and to speak about this subject to an audience where I see so many young faces. That's empowering, because to speak about the state of unconstitutional issues is a recognition that our system may be broken or is broken. We have a humanitarian crisis, an ethical crisis, a moral crisis of our system. It is complete bankruptcy. So to call up to mention this theme, to call them, to bring attention to this theme. For us, that's very important. And our young population needs to actively participate in this so that we can be agents of transformation and participate in this. Despite this concept and thesis being incorporated in Colombia, at that first moment in the years of 1997, the state of unconstitutional issues declared, which also regards our prison system. We had immediate measures, but we had an audit system that failed. So we have a reality that could not be reproduced here in Brazil. There's an article from Professor Tula Pires and Ana Clausina that they say that when you recognize a state of unconstitutional issues, that is very strong. That's a recognition that there's a systemic failure, generalized failure, that there's a humanitarian crisis, and nothing can happen. And if nothing happens after this, then the whole system is rendered ineffective and banal, and you have barbarism. That's how severe the situation is. So when we speak about state of unconstitutional issues, which was inaugurated by the Supreme Court in 2015 regarding the prison system, and later other themes that were also mentioned here by Professor Tulia, this all puts us in a place where we must, we as members of the justice system, as public servants, as professionals from academia, the magistrates, we must be put ourselves in the position and question, what may I do to also act as a transformation agent? What is my role regarding this? What changes may I promote or can I promote? I'm speaking about active citizenship. I have a different viewpoint from my colleagues, but it's about showing what our role is of auditing, of verifying, of demanding solutions and change. It's not enough for the Supreme Court to render something a state of unconstitutional issues, set up some measures, and of course when the Supreme Court establishes a law, it must audit that. You cannot leave this to the executive branch. The executive branch was already non-acting, so they must not only, so the Supreme Court must mandate the change and also audit so that we can see the changes. That's the first point. The second very important point regarding this theme, our illustrious professor just mentioned right now, is that we must be careful to not banalize the Institute. There are different questions from 2015 to the current moment have reached the Supreme Court. And we ask ourselves, we question the state of unconstitutional issues regarding taxing fuel, regarding culture. There are other demands that have been, requirements that have been reaching the Supreme Court. And there must be clear criteria for us to really understand what is a state of unconstitutional issues. It's not a mere situation that reaches a superior court that can be treated as a state of unconstitutional issues. This criteria must be very well established so that the Institute is not rendered ineffective. And something that I'd also like to mention, I was speaking to Appellate Court Judge Igreja Matos about this. There are problems that are not limited to Latin America or South Africa, where this issue has been raised, but there are problems that are transnational. We have global problems. Here, as we are currently thinking about this subject, there are issues where we have to cooperate at a global level. Climate conditions, for example, migration issues, COVID and the pandemic. We've lived through, during 2 years, a reality that had never been imagined beforehand. So we need a deeper thought into these issues. Can we think about a state of unconstitutional issues at a global level? How would this be rendered possible? Would we have to think about a cooperation among different countries? How could this be put into practice? I'm happy. Now we're having a debate on this, that we have an international congress focused on this, of having an audience of youngsters that I am sure will be, our young population will have political conscience, responsibility, civil conscience, active society, seeking and auditing the effectiveness of these rights that have been very dear to us. Our federal constitution Aires does mention our federal constitution in a poetic fashion because it is beautiful. It inaugurates, it establishes very important rights for us that are dear to us, but we need to be agents for transformation to allow that it is allow it to be effective. He speaks of activism as obligation. We criticize the Supreme Court, but when we speak of fundamental rights, we are the court is called to action. We're thankful that it acts, because otherwise we would be in an inertial system under barbarism with constitutional rights violated systematically. So these are my thoughts. This is a call to action. As in our role as jurists, as workers or students or citizens, what is our role? That is my question. What is our role to becoming transformation agent and seeking and desiring a country where we want to live? We have education, health, public security that we want to live in. A lot of things regard as the future for our children, for our grandchildren. These are also my thoughts. Thank you very much for this. Thank you. Thank you very much, Glacielle. Glacielle has written a thesis on constitutional right, looking at the Supreme Court, not regarding this state of unconstitutional issues, but considering the precedents, so we can see how enthusiastic she is. So now let me yield the word to Professor Dr. Thiago Matsushita, so that he can make his comments. Good morning to everyone. Good morning, everyone. Initially, I'd like to thank for the invite. I'd like to thank Esmat for the invite to be here. Dr. Marco Anthony, say that we're very glad to be here in this Congress that is very representative, that is very important. As Professor Lauro has already recognized, this state court school is a reference of Tocantins State, is a reference, a benchmark for other schools throughout this country. I can say very, very comfortably that there are very few schools worldwide that are so capable of drawing closer the judiciary with academia in such a competent manner as this Tocantins school does. So again, my congratulations and my thanks for being here today, and thank you for the invite. Both myself as Professor Lauro, representing our institution, FADISP, we'd like to say that we're very happy to be here. I'd also like to acknowledge my colleagues of this panel, our president of this panel, Dr. Liziane Oliveira. Thank you very much for being here, coordinating our work. I'd also like to greet all of you who are here. My dear friend, Dr. Flavia Malaquias, a former student of ours from the master's program in Goiânia. Dr. Flavia is a school director of the OAB school. Thank you very much, Dr. Flavia. And I'd also like to thank you all here. As a result of our age, in this case, it's not really, the age is not really relevant, but when we examine PhD and master's thesis, we start noticing that we're older when we speak last, when we're the last to speak. There's good and bad. The good is that if you're lost, you've heard a lot of things before, and so you may omit some comments. But on the other hand, there are other thoughts that we read, that we mention, that other colleagues of ours that come beforehand may mention things that we wanted to mention ourselves. But let's speak about the state of unconstitutional issues. Let me make two comments that are very important for Brazil's model. I think it's very important. I do believe so. First, The first one is to recognize that we are a Latin American country. Normally, for those who study the constitutional rights and the Supreme Court specifically, we know that Brazil was never really very interested in what occurred with our neighbors. We were interested in Germany and Portugal, but we don't recognize, we almost don't recognize ourselves as a Latin American country. So to have the Supreme Court recognizing an institute as important as to recognize the state of unconstitutional issues, that's a milestone in the history of the Supreme Court. To look at this issue, the state of unconstitutional issues is an institute that has a direct connection with everything that we experience in Brazil. And to add to this subject now, as Appellate Court Judge Igreja mentioned, this is not a theme that is limited to Europe or mostly relevant to Europe, because their development level is completely different than ours. And this is really what I wanted to discuss here with you, our role. I've seen that many of you here are students of the master's program here at THEMATIC.
We have law students. As a professor, I would love to get good questions from you. It's a good question to you as well, if you will care to answer it. The declaration or the recognition of the state of things. It's unconstitutional state of things. It is only, it's dealing exclusively with the effects that the stuff we go through in our daily lives. But the root cause of the matter, where the whole problem lies, is our level of development. Brazil, unfortunately, does not have enough development to not have in its daily agenda. And that's another comment that's important to make and very interesting. It's been made before. If we have dozens, if not hundreds, of cases that could be framed as an ADPF and discussed at the Supreme Court. How come we have these cases? We have them in Brazil, unfortunately, and that happens also in Latin American countries, because we have a development problem. Our development problem, it's not economic development only, because that's yet another remark made by appellate judge in Igrejas. The rule of law in Europe, they're going through a problem now, but it's a different kind of problem that's not related directly to the economy. So we're talking about development as if you have, it's in the constitutional, in the Constitution of Brazil. It's economic development, we're talking about social development, we're talking about political development, and a cultural development. With these four dimensions of development, surely Brazil wouldn't be talking about the state of unconstitutional matters. I think it's a problem. The backdrop to our discussion, unfortunately, is the fact that Brazil still has high poverty rates. If you live in Sao Paulo, for example, if you live in downtown Sao Paulo like I do, we're reminded every single day of the homeless population, every single day. People that don't have the right to a roof over their heads. People that are within the same area where we live. I look out the window and I see them every day. They don't have a roof over their heads. And a lot of them live in occupied real estate. They have minimum rights. Their rights are not enforced. And we have to live with them in 2024. We still have to live with homeless people around our homes. We are on an island of prosperity. Everybody's included, socially, politically, economically, culturally. Most rights are upheld of the people that live on this island of prosperity. But outside, when we leave this courthouse, if we look around, to other people, if we're able to see them, to look at them face to face and try to recognize ourselves in them, we're going to see how unequal the country is. We even, a short while ago, we were talking about 15, 17% unemployment in Brazil. Today, the unemployment rate has gone down to under 7%. Yet another positive result of that is that it's a constitutional right, which is the full unemployment, and hopefully we'll go down to 3 or 4% of unemployed people. That's full employment. That's one of the dimensions of our Constitution that's been upheld. Our fight is to increase the level of development so that this topic, and I hope that in 17 years' time, when we get to the 30th edition of the International Congress in Human Rights, it's been 15 years that I've been taking part in this Congress, and I'm offering my talk to be here at the 30th edition of the Congress. Probably it won't be such an important topic as it is today, 15 years down the road, because probably, and now I will give you hints about my age. Most of you have never heard of a game that we had in our childhood, especially the boys. It's a Super Triumph. It's a game with cards with cars drawn on them. And there was a card called Super Triumph. You get the card, Super Triumph, you use it for everything. It was a game played by young boys, if you will, back in the day. We cannot call a state of unconstitutional things as a Super Triumph. You have to acknowledge the importance of the legal court system in the implementation of fundamental rights. It's essential, it's crucial. These limits, this activism or this active initiative by the judiciary branch, it's the day-to-day affairs that will produce it. It's a permanent conversation in our format of the rule of law that needs to have this balance between legislative, judiciary, and executive branches of government. But it will... But there's no way to change the format of the implementation of individual fundamental rights. That's the role of the judiciary branch, to implement fundamental rights. And I would like us to look closely at and be more concerned about our national development and succeeding and having a higher rate of human development. And the harder we work towards elevating the base or the minimum requirements for decent survival, if you will, the increase of housing conditions, health conditions, and food security conditions. Brazil, we're here in a state that is a large producer of foodstuffs, and we're surrounded by states that produce animal protein or vegetable protein. It's very important, and there are many people that don't have enough to eat in Brazil. Many people don't know if they'll eat 3 times a day in Brazil. And it's ludicrous. It's absurd to talk about that state of affairs. A country that produces the amount of foodstuffs that Brazil does, one of the leaders of the agribusiness in the world, we have so many people going hungry every single day. And I would like to thank you immensely for your attention. And I would like again to thank you for the invite to take part on this panel on such a crucial topic that's so important to all of us. Thank you very much. Thank you, Professor Thiago. And now we're getting several questions. I will give the floor now to the civil servant in our courthouse, Nayana Guimarães, for her comments, and then we will start the Q&A, our debate per se. Thank you. I would like to salute everyone, a warm welcome to everyone and the members of the panel, and also all the participants of the Congress. I'm very happy to be here and be able to discuss with you such an important topic not only in the legal domain, but as many have said before me, also it's a factual importance, because in reality, the recognition of a state of unconstitutional matters must precede the effective change of, in reality. It doesn't make any sense whatsoever to bring the institute of the Colombian courthouse to our legal world, if you will. And here I will take up again the talk by Dr. Thiago Matsushita, in the sense that there is no way today not to recognize the importance of the legal judiciary branch and the full implementation of fundamental rights and the promises enshrined in our Constitution. The topic of the acknowledgement of a state of unconstitutional matters and certain subjects, it is related to the realization of the objective meaning of fundamental rights, the mission of fundamental rights. But because when the legal court system recognizes such a situation, that happens within a structural litigation process, not in a lawsuit moved by A against A, by Caio against Tissue, to, if we may recall the most traditional cases in our legal literature. This is a litigation in which the legal court system, judiciary branch, in addition to declaring a situation, they set out measures so that that situation will be modified. And that happens in a situation it's a massive situation of vulnerability of fundamental rights, and that's what characterizes the state of unconstitutional matters. It's a violation, a massive violation that affects a huge number of people that are deprived of their fundamental rights, and in a situation in which there is omission for a long time, a very frequently reiterated omission by the state powers in solving that situation, and also a situation that requires the concerted action of many departments of government with a view to solving that structural problem. These are the elements in order to acknowledge the existence of a state of unconstitutional matters, a massive violation of rights affecting a large number of people, omission, reiterated omission on the part of state officials to solve that problem, and the need for concerted action, bringing together several branches of government to solve that problem. Again, as a professor, I need to emphasize these crucial elements that actually make up the state of unconstitutional matters. The judiciary branch of government, according to our Constitution, has tools to face these situations. And one of the tools that have been used most frequently is the action of fulfillment of a constitutional precept. It's got a wide scope, and this lawsuit, if you will, the judiciary branch may analyze not only acts but also omissions by the legal powers of government that violate fundamental precepts. And also taking up again the talk by many other members of this and panel and former panels as well, there are constitutional tools to face the situation. And that's why we cannot say that there is activism in the bad sense of the term of the judiciary branch. When it recognizes a state of unconstitutional matters, when it sees fit to adopt measures to solve these structural problems. We're not talking about activism in the bad sense of the term, in the sense of interfering in a sphere of attributions that are exclusive to another branch of government. It's a constitution that opens up that possibility. And now, again, taking up again what Dr. Helvia has said, the question that she has put to our attention, I do believe that there could be a statement, a declaration of state of unconstitutional matters within the realm of a state, but since it is a structural litigation problem, we would need to prepare ourselves in order to deal with these structural litigation measures. Professor Lauro has brought to our attention the existence of a decree, a bill, a legislative bill that might shed light or bring about a solution so that the judiciary branch will be better prepared to deal with these litigation matters. There is a consensus in the sense that the judiciary branch may indeed act effectively in order to protect and safeguard fundamental rights, includes even when there is general omission. It's been ascertained that there is a general omission when it comes to structural problems and questions and issues related to economic aspects, social aspects, cultural aspects of society. These are problems that don't have just one source. They spring out of many sources. That they're complex problems that will require an action by the judiciary branch. What are the most important criticism addressed to the activities by the judiciary branch? And now I'm talking about activism in the bad sense of the term, when the state of unconstitutional matters is recognized in each and every situation in which someone doesn't like a public policy, for example. It's not enough not to like a certain public policy in existence so that you may recognize the state of unconstitutional matters. You really need to have these elements, as I mentioned, a massive violation of rights, general omission, and need for concerted activities within the powers. It's not enough not to like a certain public policy. And at the Supreme Court, we had many ADPFs in which they have brought to the fore the theory of the state of unconstitutional matters in order to change certain public policies. The Supreme Court has analyzed these ADPFs, for example, in ADPF 347, about the penitentiary system, and 760 as well, that talks about the question of deforestation of the Amazon and the natural biospheres in the country. I believe that they did a good job when they recognized the state of unconstitutional matters, and they saw fit to draw up plans and so that these situations will be properly faced. We had an ADPF at the Supreme Court in which the Federal Council of the Bar Association, because they disagreed from public policies of the Ministry of Education in the sense of opening undergraduate courses in law, they chose to recognize the state of unconstitutional matters, and STF overruled that request. They understood that it would be really not liking a certain public policy is not enough to overrule it or to delete it or abandon it. You have to really take care of these novelties and be very wary of them. Not every situation must be seen as a state of unconstitutional matters, even though we know that in Brazil there are numerous situations that would require the kind of acknowledgement that we're talking about. Professor Thiago Matsushita brought to our attention a situation which is a situation of the homeless, and there is an ADPF to recognize the situation. And in this ADPF, there is a measure, an injunction that says that states and municipalities, all the federative units and entities should and must uphold a law about the treatment accorded to the homeless population. It is, I believe the STF has done a great job in this analysis and analyzing these lawsuits. A second point that I believe would be important to comment upon is that the STF also did a very good job analyzing constitutional dialogues when it comes to these topics, because these are complex topics related to the structure of our society, and so there's been the creation at the STF of a department specialized in these structural litigations that have the goal of providing reconciliation, ensuring reconciliation, trying to establish a dialogue between legislative and judiciary branches of government of the state, so that these situations will be properly dealt with and faced. It's interesting because the goal of recognizing the state of unconstitutional matters is to set up a dialogue. It's not to create problems with another branch of government. It's let alone create a crisis among the different levels of government. But it's actually find a solution that will be beneficial to society at large. That has to be observed, and because when it comes to discussions about public policies, we need to pay close attention to the institutional abilities of each branch of government to settle certain situations. And the judiciary branch of government is severely criticized for not having this institutional ability to solve these social problems that are so complex and require public budgets, the allocation of resources.
So, how to recognize the state of unconstitutional issues in a certain subject? The goal is to set up a dialogue and not just to blame a branch or something or cause a crisis. However, there are situations where a court decision could be interpreted exactly as an attempt to infringe upon some another branch's authority, and it may bring a negative feedback or negative situations, or it may bring negative results and affect the other parties. And we've had some situations that has already happened. So in this case, we have to carefully consider if in each case is it really worthwhile to have such a strong declaration such as this one, the state of unconstitutional issues. This is a state of unconstitutional issues. If you determine that, then what you're actually saying implicitly is all of the other branches that should be dealing with this situation were not competent for that. It could be interpreted that way, that they were not adequate in their. And there's also political cost to. There's a political cost that we should think about. The Supreme Court, before this decision in the DPF 347, which was a pioneer decision in recognizing the state of unconstitutional issues, the Supreme Court had been intervening in public policies without having to issue this declaration. We had strong repercussion when we established that children's registrations in daycare would be a fundamental right to be assured. That was accepted without having to resort to a declaration of the state of unconstitutional issues. It was a very strong action. So we should actually consider the cost of such a strong declaration. You should analyze if those criteria are present that would recognize the state of unconstitutional issues, or if that is mere illegality that is, however, not as strong, should not be treated as in such a strong manner. But if it is the case where you really have to recognize the state of unconstitutional issues, as is proper in some cases, you should anyhow still seek to have a dialogue among other branches. So these are my comments. It was very good to hear my colleagues regarding this. It was good to be the last one to speak because it was very good so that I could, in fact, learn. And other comments were also mentioned, and that was very important. I thank you very much for the opportunity of being here, and I'd like to yield back the word to Professor Glacielle. Thank you. Thank you very much, Nayana. We have some issues. I was able to guide some issues or some comments, but others I would like to leave this open to the roundtable so that we could all make our own contributions. The first issue is an initial comment. What is the impact or question? What is the impact? And I'd like anyone to answer if they want to. What is the impact of the recognition by the Supreme Court of the state of unconstitutional issues in a certain situation or in that group of public policies? What is its impact on the decisions reached by the other tribunals, the lower courts, the appellate courts? Is there some change? How can we notice implementation of these decisions in a lower court setting? I would add some comments that we're speaking very much. All of the comments mention this. One comment is a declaration of unconstitutional issues. Another one is a perception while implementing public policies that it is ineffective in a generalized manner and persistent. So what is the degree of generalization or persistence that we can understand to be proper so that we can characterize it as a state of unconstitutional issues? And in what situations are we actually speaking in terms of the controls or implementation of a proper and timely policy? We could be thinking about this, and we could also be thinking or considering when we consider the inter-American system or the European system, how, in some facts, how could the Supreme Court reflect on some issues that the Inter-American Court had already been signaling that Brazil was not in line with the rules, such as the prison system and the applicability or enforcement of the Maria da Penha law, for example. So we have these issues to comment on. Would anyone of my colleagues or anyone like to comment? So let me, no? Well then let me go to a second comment. Oh, on Maria da Penha. All right. Mato Grosso's state courts have already has anticipated this response already, and this has been noticed by the Superior Court, because Mato Grosso state courts we had already been implementing this for about 6 years. So the fact that the consequence, if you will, of this decision is one of affecting all of us. We should all a decision that we should all consider. The subject is connected to the to the judicial branch as a whole, and to the state courts of all of the Brazilian states. With also the judges, it should also be with the other courts that are in charge of arresting and sentencing individuals. We should observe all of the fundamental issues that were mentioned in the decision. These are complex cases, but they are no longer so complex. Once they are now part of the agenda, they're no longer in the ordinary agenda. Now they are in an extraordinary agenda. We should now prioritize these issues and clear up any outstanding issues. So we solve the issue, we solve outstanding issues regarding it. We've been speaking for over 1 year, ever since Supreme Court Justice President Barroso decided he took on this issue in his initial inauguration speech, and he has been a flag bearer of this subject, and now all of this has been taken up. All of this whole issue has been taken up, and it is highlighted in the Supreme Court websites, and there are other social educational measures. When, for example, inmates are released, how can we re-socialize and bring back that individual that has been detained into society? Maybe empower them, provide them jobs, retrain them, and remove that citizen from the state in which he found himself previously, which was a vulnerable situation of vulnerability, which was recognized as such because a vulnerable group is underrepresented or non-represented. Detainees are not represented at any branch. They don't have no access to the executive branch, to the legislative branch, or other interest groups. So if we are speaking of legitimacy, of legitimating the state of unconstitutional issues, at the moment that the judicial branch takes on that role, we no longer deal with representation. Well, because the judicial branch, the judges are not elected. Does that mean that they're illegitimate? No, we cannot reach that. We must not answer quickly. So if I consider this, if I consider only the legislative branch has that legitimacy because they directly represent their electors, and that would be democracy of the majority, of the tyranny, where the minority is eternally vulnerable. And then we have the criticisms. I'm not a servant of the judicial branch, but that is my reading as a researcher and also as a legal scholar, because this does affect us always. Decisions affect us, obviously, but as a scholar, this is a vision, this is a less appreciated form of how we should analyze this issue, because otherwise we have answers to everything. So simplification of rights. We have interesting books. We have ways of oversimplifying complex issues, but for example, audiobooks. So you cannot replace 4 years of college with a 5-minute audiobook. I haven't understood how I can do this or in 90 minutes. Professor João Maurício has interesting comments. They're very true and very deep comments, very insightful comments. For example, I've just written my most complicated thesis, the tautology of belonging. So, Professor, philosophy of law. Has it become a bestseller? I don't know if I'd book that anthological work, perhaps because I do know him, but philosophy of rights is better sounding. So back to this issue. These are complex issues. You cannot solve this with a 90-minute audiobook or oversimplifying very complex issues or small videos that we watch on social media. So this is really something that is a problem because it's very simplified reading that we should avoid. So structurally speaking, that's the fact. There are KPIs that are being complied with right now of these agendas where the local judiciary state judiciary is understanding and complying with the solutions because of this decision, major decision. Thank you. Anyone else would like to comment? So let's head over to the second question. A comment on a state law that has been approved and has brought into force, that's 4,534, which allows that the aggressor of domestic violence against women that's the law, that the aggressor can be mandated to use electronic devices to monitoring and immediate auditing and according to protective measures. In this context, maybe electronic bracelets. In this context, using the use of electronic bracelets that are normally restricted to serious crimes, that are normally actually to less serious comments, would this be contrary? Would that not lead to a contrary result? Well, I guess it's up to me to answer. In truth, this issue about electronic bracelet monitoring for those who practice these domestic violence acts, this is to protect the victim. Normally our criminal system is geared towards the aggressor. So should it be more harming to put electronic monitoring? That's not a serious crime, but it is related to the protection of the victim. When we speak of violence against women, we are speaking about a social problem, not a problem of belonging to women. When 50,000 women are killed in one decade, that is not our problem. Restricted to women, that is a societal problem that ends up not recognizing this issue of women as being an individual or a human being, a thinking person, an action can choose. The use of electronic bracelets it could be recognized as a repressive measure, obligating the aggressor to use them and doing that to protect the victim. In other locations, there is a monitoring point. The victim receives a device that when the aggressor draws closer, that victim will push the button of that device, and then you'll have police, public security that arrives to assure that woman that she is protected. We normally like to say, we have a popular saying that those who threat do not go through with a threat. That's not true. We have to remove the possibility of an aggressor threatening and then carrying out the threat. So let me merge some questions here. One of them is, could we apply, and I thought about Professor Lauro, because it's about internet regulation. With the absence of this regulation, could that force a decision to question the state of unconstitutional issues? And regarding this also, would the state of unconstitutional issues, would it expand itself into the digital environment? Would there be a way of doing this? Would it expand into the digital domain? Well, we have a civil framework, it was interesting that the discussion of the internet, the civil framework legislation, it had the first proposal of criminalizing certain behaviors. This is over 10 years old by now. And in, for example, the last 2 years, everything has changed from the moment that we had ChatGPT. ChatGPT considerably changes what we understand is AI. Google has launched an intelligent notebook with AI built in. So I'm already considering that I'm purchasing something like that just so that I keep myself up to date. I don't have Facebook. I don't know what that is. That was my own personal decision, and I'm still alive. I'm here actually with you guys. But the world no longer is an analog world. But this, I don't think this should be a moment for declaring state of unconstitutional issues, because we are already working towards this with this new legislation that should be approved, is under discussion. The rapporteur deputy is Deputy Silva. We've had some debates, some academic debates on fake news, but I don't think this is a case of a declaration, this kind of discussion. In the United States is aware of the power of these major platforms, especially regarding social media platforms. But for whoever asked this question, Dr. Liziane, I don't know. I should invite this person to be here this afternoon, which is when we will be discussing AI. But yes, without question, much of what is occurring from this overexposure, if you will, of people to the internet, this has led to very serious consequences, oftentimes fatal. We've heard some news items of people who were not able to deal with this, were not able to deal with fake news regarding their own people, and that engendered a major crisis. So the world is aware of this power, of this overconcentration of data at the hands of just a few.
Thank you very much, Professor. What is, if this declaration, that's the next question, if this declaration of state of unconstitutional matters, can it have an impact on the effectiveness or the efficacy of norms and the activities by public agents in the promotion of rights, fundamental rights? What do you think? In reality, it should and it must actually deal with a state of unconstitutional matters followed by public policies, and we need a plan towards fulfillment. It's a structural decision. The idea that it will actually be implemented, it's not enough to have it on paper. It will have an impact on the lives of all of us, as Dr. Lauro said. The EADPF 347 on the penal system, penitentiary system, calls for measures that must be implemented immediately. There is a 6-month plan, and but some initiatives were fulfilled immediately, directed to the judiciary power. The custody hearings, for example, within 24 hours. The idea is that the omission will be settled through a structural decision. And hence the participation of everyone is very important. The Public Attorney's Office, public defenders, organized civil society, NGOs, everybody must be imbued with a need to implement and uphold the structures, so we will avoid the banalization, because it's a topic dear to all of us. Yes, we need to implement decisions, and the structural decision is the starting point for that to happen. I would like to add an interesting remark. Speaking about Portugal, not only Europe, but specifically Portugal, I see myself in a lot of the things that my panel colleagues said, and I would like to thank you for inviting me to be here today, and the fact that you're here in the audience, and the privilege to share this panel with such distinguished speakers from whom I have learned a great deal today. So it has been said here, the prudence and the use of that institute, of that tool, number one, point number one. Point number two, the institute, as has been explained by my colleague, the colleague to my right, is strictly linked to development. It's closely linked to development in Europe, even though there's no direct application in Latin America. This is a reality, and that has to be borne in mind. And actually, when it comes to development levels and the prudence and the use of this tool, we got to a conclusion which is quite worrisome, and I'll explain what I mean now. In March this year, the Relations Court House of Lisbon, Portugal, made a decision by 3 judges, a majority vote, and it's 2-1. It's a question that's quite controversial, but they made the decision of refusing the extradition of a Brazilian citizen to Brazil. And the reason alluded to, they made reference to the DPF 347. And the rationale was simple. If Brazil itself, through its Supreme Court, recognizes that there is a structural problem, systemic problem in Brazil's judiciary, penitentiary system, I must not accept that this Brazilian citizen be sent back to these jails where there is a systemic problem. And due to the repercussion of a decision like that, it's not just national, it is over time, and it's got ripple effects at the international level as well. And that there are 2 issues here. On the one hand, there is a certain deficit of trust in the judicial system in Brazil, in the case the penitentiary system in Brazil, which may be saying negatively in terms of what the credibility of a country entails, and that sends us back to the beginning of what I said before. Extreme prudence and the use of this tool is essential, because afterwards the consequences are unpredictable. I believe that a country like Brazil, for example, or Portugal, wouldn't be satisfied. They wouldn't be happy to say that another country doesn't recognize your penitentiary system as good enough to host a citizen that is in our country. And I'll wrap up now. In 17 years, we won't want to hear about the state of unconstitutional matters. That's a big challenge to a country like Brazil. Thank you, Appellate Judge Igrejas. I would compliment your remarks. I would only like to make a comment on Dr. Igreja's remarks. It's a question of prudence and how that can be used politically. The question of unconstitutional matters in the penitentiary system of Brazil, it was used in the decision not to authorize the extradition. And the recognition, I think, of the state of unconstitutional matters and environmental affairs for Brazil internationally would be devastating, and from a political perspective, to recognize the state of unconstitutional matters. And all on the other hand, other situations recognizing the state of unconstitutional matters would bring about a negative view, but actually a positive view, to showcase an action geared to combating certain situations of social development that haven't been able to overcome, but there is recognition thereof. For example, the gender issue, the violation of the rights of minorities, the question of that was brought to our attention by our colleague, the homeless, in the state of Sao Paulo. Recognizing these situations, I think that that could lead to a view, a political view that's not negative, but actually positive, demonstrating a concern. And also, in addition to this concern, and politically, this concern would have ripple effects, negative ripple effects. I think that you have these two biases, these two slants that could happen due to the declaration of the state of unconstitutional matters. And I think it's more interesting to focus on real cases. I agree with you fully. I couldn't agree more with what you just said. There is a positive dimension when you assume the problem. You don't sweep it under the rug, and you proactively try to solve it, and you try to find a solution to it. And I must underline the fact that even though it seems a bit distant from our debate, it's a decisive issue in Brazil and in Europe as well, in Portugal, which is domestic violence. It's a social scourge. We've been trying to find solutions to it. I could quickly share with you 2 or 3 ideas because I know this is a dear topic to my colleague. They work on this issue day in, day out, every single day. A lot of you judges in the audience. Specialization by police departments and the public attorney's office. Every time there is a claim of domestic violence, the first impact is decisive. We must find solutions within the police system. Those who get the complaint, it has to be a person specifically trained to deal with that situation. And then later, that's the effort we're trying to make, and monitor, directly monitor. That's not a novelty to anyone. And also, that perhaps that's what I've heard of recently. It's most interesting. I'd like to share with you. There's something we've had recently, a protocol with a French court system in which that was tackled. The refuge home, if you will, the haven, safe haven. The victim is taken to a safe haven, if you will. And we have the transition home, trenchant home, that's not being called into question, the immediate danger, moment of danger, but we have to ensure the safe transition of that victim in order for her to be able to go back to society and her daily life. But now there is a project, it began in the north of France, that I think it's very interesting, in my opinion. It's a home for the aggressor, the violator himself. Either it's a situation of violence that requires the deprivation of freedom, or it's a situation that ultimately won't allow deprivation of freedom. And we have re-educational homes that have 2 components. For this case, in which you shouldn't actually arrest the perpetrator, but in the second case, the perpetrator that has already left jail, but he is still not he does not have the conditions to be freed without control, to be released without control. So you have homes for both of these situations. What's the immediate advantage? One of the problems we have, at least in Portugal, I don't know about Brazil, but is that the victim has to leave her home ultimately, and the perpetrator, if he's not arrested, he's there, he's living there. So the victim, the children have to reconstitute their lives, their schools and their transition homes. And when really the person who should be penalized is the perpetrator, is the aggressor. So the fact that you have homes, you call them re-educational homes, you have follow-up psychological treatment and so on and so forth, normally linked to addiction, and you have the advantage of keeping the victim and her children, who are also victims, in the same family home where they always lived. I thought it was very interesting, and I would like to share it with you. Sorry, we're running out of time. I apologize to the moderator for my long remarks. No, actually, your remarks were quite opportune. It's a topic that is very dear to all of us as jurists, and some of us actually work on a daily basis dealing with this topic and researching it as well. That was an excellent remark. Thank you. Well, going back now to our former topics, there is yet another element. Nayara was talking about it in her talk. She mentioned something that came slightly afterwards. I would ask you to take it up again, which is to highlight the requirements so you will actually frame the state of unconstitutional matters. I don't know if it was you or Thiago that mentioned it, Dr. Thiago. Before answering, I'd like to comment on the case of Portugal that was brought to our attention. I remember the figure of trans-constitutionalism, the impact of a decision by Colombia and its impact in Brazil and in Europe, and it's a situation of one individual concretely that was about to come back to Brazil. So it's very nice to see this the ripple effects of that situation, to share this concept of the state of unconstitutional matters as it applies to so many situations. And just to answer your question directly, to frame the state of unconstitutional matters, at least analyzing the requirements that were set by the Colombian court and brought to Brazil, it is necessary to have vulnerability, massive vulnerability of fundamental rights, and that will reach a large number of people. It's not enough to have 1 or 2 or 3 victims, but a large number of victims. You need to have a structural problem stemming from economic, social, cultural issues in our society that will require complex resolution, and you need to have omission for a long time. Omission, important omission, generalized omission, and to solve these issues, and you need to have concerted action by all the branches of government and several sectors within society. Basically, it is these 4 requirements that you must have aligned so you will acknowledge the state of unconstitutional matters. But it's very interesting to know whether the state of unconstitutional matters, as it has been acknowledged, ascertained by the STF, the Supreme Court, whether it will be identical with what happened in Colombia, or rather, if there are differences. That is an issue for research purposes later, to ascertain whether the Institute was brought about exactly as it was, or whether the STF did some changes, important changes to it, because institutes are not immutable. They're not impervious to change. There might be differences between the Colombian court and the Brazilian court. Thank you so much. I think that this has been a very fruitful panel, a wonderful debate on an important topic that leaves for all of us. This is a recent topic. There are elements for research. We've had undergraduate students and master's students as well. Yesterday they presented their initial research on the panels, and one of them brought to us the ADPF and this topic. And today you noticed that in the talks by our colleagues and panelists, there were several elements that could be the subject of research. The effectiveness or lack thereof of a policy, the implementation or lack thereof of these initiatives, and how it's implemented in each state, and then on down to the municipalities, and then the executive branch of government, state level, municipal level, and the federal level of the executive branch of government, decisions by the STF, the upper court, and so on and so forth. We have several elements, and I'd like to just make a quick comment as an environmentalist and as an international expert on the question of environmental issues. It's something that concerns me, Appellate Judge Igreja and Dr. Tulia as well. Whether in Brazil, if Brazil declares there is an ADPF in which we're urging to declare deforestation as a state of unconstitutional matters, whether it's massive, generalized, that we cannot control, and that's stated and recognized by the court. If there is an international impact in a magnitude that we cannot even measure the effect, the domino effect of that recognition, because in the European Union there's been a resolution establishing the criteria to market and commercialize. The absence, the product must not have been originated in areas marked by deforestation. And we've seen the impact of those ordinances. In the case of the French court system, involving, there is a French supermarket network of supermarkets that purchased beef from a Brazilian company. And so there are impacts, ripple effects, and the careful use of the institute. Of course, the courthouse, the STF takes care to issue proper decisions, but the actors and agents of the ADPF, because what we have noticed in the talk by my colleagues and some readings that they have done of research that looked at all the proposals, that in reality sometimes it is framed as something trivial, something banal, without taking into account all the features. For example, a case of fuel, perhaps. So these elements, there is a margin for research and investigation, academic research, and a margin for learning, a great deal of learning for practical implementation. We have civil servants and magistrates and agents and actors involved in the whole situation. And of course, we jurists, students, and researchers and judges, I'd like to thank you for your participation and this panel, and you, ladies and gentlemen, students and professors and professionals in this morning session. I'd like to invite you to come in the afternoon for panels dedicated to artificial intelligence and the technology applied to the legal court system, and digital justice, and so many relevant topics. Thank you so much. See you all in the afternoon.
Ladies and gentlemen, I'd like to thank the coordination and all of the panelists. We'd like to invite Maria Luisa Nascimento, coordinator of the postgraduate study at the THEMATIC, to deliver the certificates to you all. But just to break protocol, I'd just like to call someone, Deborah Galante, to deliver the certificates together with me. And And I should, this certificate, I should really highlight that she's the newest professor at the Magistrate School, Dr. Nayana. And our next certificate to Dr. Glacielle. Dr. Helvia Tulia, judge, magistrate, a magistrate, and a PhD candidate. Soon to be a PhD candidate. Dr. Helvia Tulia will be wrapping up her PhD candidacy this year. And our dear friend, coordinator of the PhD program, Professor Liziane. Could you please all join, or could you please hold your certificates for the photograph to show them? And for the group picture, please. This group really deserves a warm round of applause. Thank you very much. We will now have an interval for lunch, ladies and gentlemen, and we'll meet again at 2 p.m. Thank you. Welcome, Doctor. And also regarding the International Constitutional Court for the assurance of democratic and human rights, we'd like to invite at this very moment the panelists. Dr. Thiago Matsushita and Dr. George Andropoulos of the John Jay College of Criminal Justice, U.S. Please, gentlemen. I would like to yield the word to the coordinator, moderator. Good afternoon to everyone. So let's get started in this afternoon period with the final activities before we wrap up the 17th Congress, International Congress on Human Rights. So let's get started with our debate. It'll be a lecture and debate. As mentioned, it's regarding the International Constitutional Court to assure the democratic and human rights. So let's start with initial comments from Professor Dr. George Andropoulos. Professor George Andropoulos is a political science professor at the John Jay College of Criminal Justice and Syracuse University of New York. He is the founder of the International Center for Human Rights at John Jay College. He's taught at Yale University, where he was associate director and founder of the Orville Skell Junior Center for International Human Rights. He's written on international human rights and humanitarian human rights. He's been a consultant to NGOs and other international organizations. He was also president of the study section, interdisciplinary study section at USCA and human rights at APSA. He's concluding a book on the UN Security Council and also counterterrorism. He's chief editor of the magazine Human Rights. Again, yielding the word now to Professor Andropoulos. Thank you.
Good afternoon, everyone. It is a great pleasure to be here again at the International Congress on Human Rights. And I would like to take, first of all, the opportunity to thank Judge Marco Villas-Boas and Professor Tarsis Barreto for their kind invitation for me to participate, as well as I want to express my thanks to the staff of SMAT for an extremely well-organized conference. I have to say I am impressed by the precision, the promptness, and the ability of the staff to take care of everything. So please join me for a round of applause for the staff and for the interpreters, that they have done a terrific job. In fact, I'm tempted to steal some of them and bring them to New York to help me when I'm organizing conferences. Now to the subject matter. I would like to, and I will speak slowly so that I make the task of the interpreters easier. My topic is the genocide question before the International Court of Justice. And this is a very somber and serious issue. When the Genocide Convention was adopted in 1948 and entered into force in 1951, there was a hope that the international community had learned something from the horrors of the Second World War and would be prepared to do something more serious about the prevention, or if it were to occur, the punishment of the crime of genocide. And yet, the convention itself, the way it was phrased when it came to the enforcement, ended up being unenforceable. And what do I mean by that? If you look at Article 6 of the Convention, genocide is supposed to be punished in one of two ways. Either in the courts of the country where it is taking place, or by an international penal tribunal. Now, think about it. How likely it is a country that commits genocides to prosecute those who organized it, orchestrated it, and perpetrated it? Highly unlikely. Unless, of course, the government were to be overthrown and replaced by another government who would prosecute its predecessor regime for the atrocities committed. The other option was an international penal tribunal. This was an idea that was discussed at the first time during the 1930s. Well, guess what? We had to wait until 2002 to have a permanent international criminal court. So from 1951, when the Genocide Convention entered into force, until the first case went before an international tribunal, which was the International Court of Justice, but which is not a penal tribunal, is a tribunal that adjudicates disputes between states. Kind of, it is a civil tribunal, let's say. It's not a criminal tribunal. The international community did nothing, despite the fact that there were arguably many instances in which we had seen massacres, persecutions in the international community from 1951 until the first case hit the International Court of Justice in 1993, that the international community did nothing about genocide. Now, why did things change in the 90s? And now we have many cases that have gone before the International Court of Justice, as well as in tribunals that were created, international criminal tribunals, after the end of the Cold War. Well, there are several reasons, but I will highlight two. Clearly, the end of the Cold War helped. That is, the bipolar confrontation between East and West that paralyzed a lot of initiatives at the United Nations was lifted. And that gave opportunity for other issues which were downplayed during the Cold War, like human rights violations and humanitarian law violations, to acquire a higher profile and attention. In addition, the international community, after the end of the of the Cold War, started paying more attention to civil conflicts, which were proliferating in different parts of the world. And these civil conflicts, regrettably, were characterized by massive and systematic attacks against civilians. In fact, in many of these conflicts, attacks against civilians the victimization of civilians was not an unfortunate byproduct of legitimate military operations. And what do I mean by that? That is, you bombard, let's say, the army barracks of your opponent, and close to the barracks there are a few civilian installations, and you have certain civilians killed. This is sometimes allowed under the laws of war as collateral damage, which is a very problematic expression, but I'm not going to get into that now as to why. Anyhow, it was not that they were fortunate byproducts of legitimate military operations, but in many of these conflicts, the civilians were targeted themselves. It was one of the war aims of the parties to the conflict. Okay? To either exterminate them or to force them to leave the place where they were going, so as to render the disputed territory ethnically cleansed. So in response to that, the United Nations Security Council established two criminal tribunals. In 1993, it established the International Criminal Tribunal for Yugoslavia. And in 1994, the International Criminal Tribunal for Rwanda. The former to deal with the horrors that were unfolding in the former Yugoslavia, the latter to deal with the genocide in Rwanda. But I'm not going to deal with the criminal tribunals, but they are relevant because the International Court of Justice, in adjudicating cases that have gone before it, has drawn extensively on the work that these ad hoc tribunals have done. And eventually, of course, we had in 2002 the entering into force of the Rome Statute and the establishment of the International Criminal Court. So suddenly, we have a plethora of mechanisms to deal with some of the worst crimes. We have the International Court of Justice, which, as I say, deals with disputes between states. It's not a criminal court. But then we had criminal tribunals, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the International Criminal Court, and we had also a series of other hybrid tribunals like the Sierra Leone, East Timor, and so on and so forth. I will not get into those. So, now, let me turn my attention to the ICJ, which was the first court that dealt with allegations of genocide raised by one state against the other. And this was an application filed by Bosnia-Herzegovina, alleging that the forces of the Federal Republic of Yugoslavia, that's how it was called at the time, were engaging in acts of genocide. Now, one of the first issues that the court had to deal with and had to make a decision, and this is why we hire lawyers, because they like to play with words and try to parse them and try to make arguments, sometimes ingenious arguments that make sense and sometimes ingenious arguments that not necessarily make sense. And I speak also here not as a political scientist only, but as a lawyer, because I also am trained as a lawyer. The convention is the convention on the prevention and punishment of the crime of genocide. Now you will assume if a state has an obligation to prevent and punish genocide, has also a responsibility not to commit itself genocide. Kind of obvious, you would say. Well, no, it was an issue to be argued about. Because some people say that The state has an obligation to prevent and punish genocide by targeting individual perpetrators. But nowhere does the convention says about the state's responsibility in engaging or in orchestrating, let's say, a genocide campaign. The International Court of Justice, correctly in my view, said this does not make sense. You cannot say that you have an obligation to prevent and punish genocide and that you don't have an obligation to commit genocide. However, others disagree, not in the sense that the state does not have an obligation not to commit suicide, but they say that that obligation does not come from the treaty itself, but from a customary law obligation. The other issue, however, which I would like to focus a lot of my attention, is about the subjective element of the crime of genocide, which is kind of interesting what the court said about that. When eventually it reached its decision in the Bosnia-Herzegovina versus, at that time, at the end, by the time the court issued its decision, it was Serbia and Montenegro, not anymore Federal Republic of Yugoslavia. Now, the thing that distinguishes genocide from other serious international crimes like crime against humanity, and why it is considered the crime of crimes, although, if I may interject something here, I do have a problem when I see in some of these proceedings states before the ICJ or individuals before the International Criminal Tribunal strenuously trying to avoid indictments on genocide. But it's somehow they are not as concerned if there is the indictment about crime against humanity, as if it is okay to be convicted of crime against humanity but not against genocide. Anyhow, so what distinguishes the crime of genocide is the dolus specialis, the special intent. That is, you are not targeting a civilian population as part, let's say, of a campaign which comes under the rubric of crime against humanity. By the way, I should add here that the crime of genocide comes out of the crimes against humanity category. For those of you who may remember your high school biology, the analogy here is to think of crimes against humanity as the genus and genocide as the species. That is one of the crimes against humanity that distinguishes from other crimes against humanity because of the dolus specialis. So the dolus specialis, the special intent, is that you are targeting a particular group with the purpose of eliminating it. That's what distinguishes genocide. Now, interestingly enough, the International Court of Justice, in its decision, set a very high bar for the proof that genocide was committed. And more specifically, the International Court of Justice ruled that in order to prove special intent, the actus reus, so to speak, I mean the killing of things or creating conditions that make the livelihood of the group, the targeted group, very difficult to sustain and so on and so forth, must be the only possible explanation for this behavior. Okay? That is, if you have a certain activity like killing, targeting of a particular group, that can be an act of genocide, satisfies what we call the actus reus, But in order to obtain a finding that genocide on committed actus reus is not enough, you must have the requisite mens rea. And the mens rea in that case is that the only possible conclusion that you can draw from that activity is that it was done with the express person to eliminate the group, in whole or in part. Not to scare the group, not to make its life difficult, not to basically create incentives for the group to relocate and so on and so forth. Although there have been findings in other courts in which they say that ethnic cleansing can be an element in the crime of genocide. But the only possible explanation must be the elimination of the group. Now this is a very high bar to meet. And the court, after going through the different cases, the different instances, the different killings that took place in the conflict in Bosnia-Herzegovina, found out only one case that fit this combination of actus reus and mens rea. That is not only the act itself which led to the physical elimination, they saw that in several, but combined with a specific intent to eliminate the group, and that was the only possible explanation that could be given. In Srebrenica, for the massacre that occurred in Srebrenica in July 1995. So, as a result, now the killing of Srebrenica, the troops and the forces that led the effort were not the forces of Serbia, but the forces of the Bosnian Serbia, the Republika Srpska, which was a self-declared independent state but was not recognized by any other entity but Serbia. And of course, one of the critical questions was Serbia itself responsible for that? Or it was the work of the Bosnian Serb forces? And in a ruling that was considered extremely controversial and debated, hotly debated, and I personally have some problems with that ruling, which I'll be happy to elaborate during Q&A, was that although there was some connection between the Serbian government and the forces of the Serb Republic, they were not the forces of the Bosnian Serb under the effective control. That was the standard that they used of the Serbian Republic, and therefore they were not responsible for the commission of genocide, that particular genocide. However, interestingly enough also, the court ruled that Serbia was responsible for failing to prevent genocide. That is, they could have taken certain actions to prevent the Serbian forces, Bosnian Serb forces from engaging in these activities. And also for the punishment. Why? Because they shielded perpetrators from the Bosnian Serbian community who were responsible for these killings. They did not prosecute them, or they did not extradite them to the ICTY. So Serbia was responsible for failing to prevent genocide, failing to punish genocide, but not committing genocide, which was greeted in Serbia with some kind of a sigh of relief. And I will discuss in a way why what is the explanation for this. Somebody needs to take into consideration the political context within which this case was unfolding. Now, personally, and this is my view, I consider the bar that the International Court of Justice has set in order to identify and determine special intent as too high and too problematic. Why? Because now it has opened the gate for other countries that are accused of genocide to use as a defense when they go before the ICJ or when their individuals are hauled before international criminal tribunals, that yes, we may have engaged in some killings. Yes, some of our forces may have overreacted, but we did not commit genocide because that's not the only possible explanation that you can give for the conduct. It could be crimes against humanity, as if this is okay. But anyhow, avoiding the stigma of genocide. We saw that unfortunately paying out in another case which went before the ICJ, which was the case concerning the Rohingyas in Myanmar. I will say at this point, however, I will not use the term Myanmar, although this is the official name of the country, because this is a term that has been, the term Myanmar was given by the military regime that took over in that country. The name is Burma, so from now on I will refer to it as Burma. So, Gambia brought a case before the ICJ concerning what was happening to the Rohingya community in Burma. I don't want to get too much into the background. I will be happy to answer when the time comes, but Rohingyas is a Muslim minority which has been systematically persecuted by Burmese governments. And there are credible allegations that they have been subjected to genocidal conduct. The majority, by the way, of the Rohingya community lives in one of the biggest refugee camps outside the country. They live in the Cox's Bazar in Bangladesh. Anyhow, the counsel for the Burmese government in the proceeding before the ICJ, the question was, the Gambia, in addition to asking the court to indicate a finding of genocide, which means that will be decided on the merits and it will take a long time for a decision, asked also for an order of provisional measures of protection, that is, asking the court to order interim measures of protection for basically to ask the Burmese government not to engage in a particular conduct until, of course, the court reaches a decision in its merits. And what was the argument that the counsel for the Burmese government offered? In order to argue against even the ordering of provisional measures of protection, that we are not talking, in order, the court says, to order provisional measures, you have to have a finding that genocide has been committed. And with the evidence that the court already has in its hands, that's not the only possible explanation that can be given for the alleged conduct of the Burmese troops. It can also be a crime against humanity. So trying to say to the court, don't order any provisional measures of protection, because there is also the options of another offense that is not genocide. The counsel for Gambia correctly, in my view, argued that at the preliminary stage, you cannot say we cannot order anything because there is another option. The question at the preliminary age of on the provisional measures, the court should examine both options, and if there is a chance that genocide may have been committed, to order measures of protection to say don't continue to engage in this conduct until we have a decision in the merits, and arguing that such a decision, such a finding can only come on the merits phase, not on the provisional measures phase. And it was absolutely correct on that, in my view, and the court did not buy the argument of the Burmese government and order measures of protection, which of course the Burmese government has ignored. Now, there are other cases I could talk, but I see that my time is approaching, so I would like to conclude with a couple of notes. First of all, on the legal front. One of the concerns that I have personally is that it is becoming easier for cases, genocide cases, to go before the ICJ and get a ruling on provisional measures. But it is becoming increasingly difficult to issue a finding of genocide in the merits phase of the proceeding. So, it is easier to enter the court and seek some interim measure of protection, but I'm very skeptical of whether we are going to have findings of genocide on the merit phase, exactly because of the very high bar that the ICJ has set for a finding of special intent. Now, what are the implications of that? The implication of that, and if you look at the only case that so far we had a finding of genocide on the merit phase, involved a non-state actor, the forces of the Republika Srpska, which was not recognized as a state. Serbia did not get this finding. I would also argue, if for political reasons, it will be very difficult to issue a finding of genocide for a state actor. And we have, of course, we'll have to wait and see how this play out, of course, because we have also the cases with Israel and South Africa that are pending, as well as the case of Ukraine and Russia. But for several reasons, I think it will be very difficult to envisage a scenario in which, for example, Russia is found having violated its obligations under the Genocide Convention, because that will create a constitutional crisis within the United Nations system, for example. It will be very difficult to justify having a seat as a permanent member in the Security Council if you have committed genocide. And of course, it will be interesting to see how the international community will react in such a scenario. But for this reason, I think it is highly unlikely that something like that will happen. For political reasons, I think it may be very difficult to have an issue of finding of genocide for Israel, but that remains to be seen. If I were to make a prediction, and I will conclude with that, from all the pending cases, and I will be happy to elaborate during Q&A, the only case that we may have a finding of genocide in the merits phase will be the case of Burma, which indicates, going back to my initial comments about genocide being the crime of crimes. It took us a long time to arrive at the stage in which we could adjudicate these cases, either before civil proceedings or before criminal proceedings. But yet, because of the political dimensions within which these mechanisms are embedded, it may become easier to have provisional measures of protection, but increasingly difficult to have a finding of genocide on the merits phase of the proceeding. I hope I'm wrong, but judging from the record so far, I think the fight to really address the scourge of genocide continues. Thank you.
Bom, nós agradecemos as palavras do professor doutor Jorge Andropoulos, palavras fortes, né, que nos fazem refletir e pensar nas questões atuais, né, quem tem acompanhado aí os jornais, né, pelo menos nas últimas semanas. Bom, dando seguimento, então, a palestras, vamos, então, oportunizar o momento de fala ao professor doutor Thiago Lopes Matsushita. Professor Thiago Matsushita.
Professor Matsushita is a member of the State Council of Education in São Paulo State since 2018 and the director of the School of Uni Alpha since 2021. Is a professor at Siena University in Italy and a coordinator of the Summer School of Democracy and Development of the same university. He is a professor at the Master's and PhD programs of São Paulo University and São Paulo Catholic University, where he's director of the graduate program. He's a visiting professor at the following universities: Cambridge University, Université de Paris, Panthéon-Sorbonne, Glasgow University, London School of Economics, and Università di Siena. I'll give the floor now to Dr. Professor Thiago Matsushita. Good afternoon, everyone. Ladies and gentlemen, I would like to thank you, especially Professor Vinicius, for the invitation to take part on this panel in the afternoon. And I would like to record once again a special note of thanks to Appellate Judge Marcos Villas-Boas, and to say that I am pleased and happy and honored to be here participating in the 17th International Congress on Human Rights in the morning. If you had the chance to be here in the morning, I have invited myself for next year too. So, and I said that I wanted to do it like Appellate Judge Igreja. For over the past 15 years, I've been around, so I'm actually thinking about the future, the 34th International Congress on Human Rights. I hope to be here to talk about, it's been over 15 years I've been participating in this Congress. This is just to say how happy I am to be here in such a special week, as it is the week in which we have approved the doctoral program in our school with the Federal University of Tocantins. I even said that I would like to reinforce and strengthen, which is undoubtedly, this is the best school for judges that's best related to the academic circles of Brazil. Undoubtedly, it's the best school with the best dialogue. Sometimes if you're in academic circles or in academia or in the judiciary, we tend to be apart from each other, and the work you do here at SMAT is stellar, together with University of Tocantins and other institutions. I'm representing FADISP as well. I'm positive, I'm absolutely sure that this is a great opportunity for us to be able to be discussing such important issues with judges and the state court and international experts as well. And I would like also to thank you for the opportunity to and the invitation to be part of this panel. And I will read out the title now, but please bear with me. It's the panel on the International Constitutional Tribunal to ensure democratic and human rights. I remember that I had the chance to take part in 2015 of a seminar in the city of Rabat, Morocco, coordinated by Professor Paulo Ferreira da Cunha and by Professor Dominique Rousseau and by Professor Rick Palat, on the creation of a constitutional court, international constitutional court, and splendidly he explained, Professor George, actually, who spoke before me, he told us about the cases before the court, International Court of Justice, the ICJ, and the International Penal Tribunal, and what are the jurisdictions that are
competentes
that are
para aqueles
competent
tribunais.
for
E
those
fica agora uma
tribunals. And
pergunta
the
do
question
porquê
remains,
de
why
uma discussão de uma
are we
Corte
having a discussion
Constitucional
on a constitutional,
internacional?
international
E
institutional
gastamos
tribunal or
os
court?
3 dias
And we've been,
daquele seminário,
and we were there for 3 days at that seminar. We
livro
published a
em
book
inglês e
in English
francês
and French
sobre esse
about this
tema.
topic.
E as nossas
And
principais
our main
discussões
discussions
lá, e
at
vou
that
tentar
time, and I'll
aqui
try
sistematizar
to summarize them a
daquilo
bit,
que a gente
the main
trabalhou,
issues,
discutiu,
salient
enfim,
issues that
sobre
we
a possibilidade
discussed, and the
de criação,
possibility of
era
creating such a
primeiro
tribunal was, number one, to try
da
and
necessidade.
the need.
Por
We
que
discussed the
se
need.
criar
Why should we
uma
create a
corte
tribunal,
constitucional
constitutional
internacional?
court, international constitutional court?
Essa discussão ela teve início, evidentemente, a
discussion
partir da
got
Primavera
started,
Árabe. Então,
after the
com a
Arab
Primavera
Spring,
Árabe,
with the Arab Spring,
países que estavam, que não
countries
tinham as suas jurisdições
that
nacionais,
did not
as
have
suas
their
jurisdições
national,
internacionais
that did
para
not
nos
have
proteger,
international
a sua
jurisdictions to
população não
protect them.
tinha a quem recorrer.
Its population
Em
of the Arab
especial
Spring
na
countries
Tunísia,
could not
grande movimento na
had no one
Tunísia
to
para a
go
criação
to. There was
dessa corte
a movement in
constitucional
Tunisia to create this
internacional
constitutional and international
fez com que a gente
constitutional court.
debatesse esse tema.
That
Aqui
had
no
us debating
Brasil,
this subject.
evidentemente,
Here
a
in
gente
Brazil,
tem
evidently, we
aonde
have
recorrer.
who
né? O
to
Brasil faz
refer
parte
to.
do
Brazil
sistema
is a
interamericano
part of the
de direitos
inter-American
humanos.
system of
né?
human
Estamos
rights. We are
dentro do sistema
included
americano
in
de
the
proteção dos direitos humanos.
American
Mas quero fazer uma
American
ressalva
system
aqui.
of
O Brasil
protection of human rights.
enxerga
But
com
as an
muita
aside,
cautela,
Brazil
às vezes,
is very cautious,
até em
oftentimes,
demasia,
perhaps
por conta de
even
convencionalidade,
too much.
né?
But this whole thing of conventionality, this issue of conventionality, which is the possibility, admitting the possibility of accepting decisions of international courts and tribunals here in Brazil. So this conventionality control in Brazil is still in early stages. If you, for example, remember, or I don't know if you've remembered when there was this, when there was a judgment of the Mensalão case in Brazil's Supreme Court. At the end of one of the sessions of the court hearing, the president of the Supreme Court at the time, Joaquim Barbosa, in light of the presence of one of the lawyers, he was there and he said, he said this kind of decision belonging to someone who does not have standing at the Supreme Court, there's no possibility to appeal, or there's no assurance of the double level of the double instance of jurisdiction. This infringes on human rights, and at the time, people laughed about that. Unfortunately, that still happens. We do not have this recognition. And in the morning, we were speaking about the states of unconstitutional issues. And at that moment, or that opportunity, we were speaking about bringing from the outside a decision from the Colombian Constitutional Court. They're very capable in the conventionality control. Mexico also has this control of conventionality that is very well implemented. But Brazil still does not have this culture of internationalizing these decisions. Europe has an integrated system of conventionalities. We do have this problem, this difficulty in observing international decisions. And we had yet another discussion. Why should we create a new constitutional court, a new international constitutional court? It would evidently have jurisdiction for caring for democracy and to take care of the defense of human rights. I remember that that last week and the other week there were decisions rendered by Venezuela tribunals and Argentinian tribunals, one ordering the arrest of the president of the other country. But that is a condition that is under actually that is under judgment in the in the International Criminal Court because Venezuela was accused of lack of transparency in its elections, and the Argentinian court advocated or brought to itself this jurisdiction. The Argentinian court decided that there's no democracy in Venezuela. It brought to itself, it took on this responsibility and made the decision to arrest the president of Venezuela. This is Argentina. But think about those who have no one to refer to or to appeal to, especially, for example, countries from the East. They're there. There's major discussion going on over there about the creation of this International Constitutional Court, as well as ably mentioned by Professor George. There are difficulties in implementing these international organisms and agencies. It's very complex as well to reach decisions. Normally, these decisions are rendered very slowly. They're not able to, in real time, accompany the speed of the problems that occur. For that, there are other more important mechanisms for that. And Professor George provided a timely example of the Israel war, which is no longer against any one country or a group. This has disseminated because of many reasons. But the UN Security Council itself is not quick enough, is not able to be quick enough to render the decisions that are necessary. So there's a lot of difficulties in trying to look after a population so that we can defend the democracy of that country. Another major concern that we had at this opportunity was regarding the obligatory character. How will you apply this decision? The enforcement. How are you going to enforce this decision? How can we force the decision, the enforcement of it? We've commented this morning about the decision rendered by the Inter-American Court on Human Rights regarding the Maria da Penha legislation, but the law itself was a reaction. Brazil did not recognize the decision of the Inter-American Court of Human Rights. Brazil has never recognized any decision by the Inter-American Court, and we have a relatively, considering other democracies worldwide, Brazil is considered a democratic country. Even so, notwithstanding this, Brazil did not recognize this decision. So we have major difficulties. It would be difficult for us to have these, it would be difficult for us to have implemented the decisions of a future international or national constitutional court. And on the other hand, we have this other extreme of this enforcement, which led to the creation of the Afghanistan war. The United States found appropriate, even against a decision by the UN Security Council. The United States simply said, "I'm going to invade Afghanistan to free the population," and that's when the war on terror got started. It's very sad, very costly, this war against terror that occurred and was prosecuted for many years, uncountable trauma for the whole world, human rights violations at all levels. So that was this is yet another consideration we must have when we're thinking about a possible international constitutional court. And my last comment would be regarding this international constitutional court. Is that this is perhaps utopian? Why? should we live through this utopia of human rights? This is a permanent need. Up until a few years ago, we still did not have the recognition, the violation of human rights beyond specific borders. For example, companies, US-based companies, European companies had their headquarters in these developed countries, but they had subsidiaries in other countries which submitted individuals to exploitation in other countries, exploiting them in different manners. There were companies that violated rights in Africa. There were companies that violated rights in China, that violated rights in the Middle East. And now there's much more control over this. And not only control, not only legal or jurisdictional control, but even more important are the societal controls that are undertaken regarding, for example, private companies. This is a major response that society can provide. We're not speaking of places that or countries that violate human rights that are thousands of miles away from here. Let me provide you the example of São Paulo, Brazil's biggest city, which with a very with a mid to high level neighborhood, Pinheiros. There was a lady there that was submitted to slave-like labor. She was a maid, and she had been a maid for over 30 years. This was found, and she had been working for 30 years without even being paid in a mid to high level neighborhood in São Paulo, or even here in Palmas, in Bom Retiro, another neighborhood in São Paulo. Actually, there's another neighborhood in São Paulo that occasionally there's a labor ministry, a task force that raids neighborhoods to protect Bolivians who live under subhuman conditions, under slave-like labor conditions in São Paulo, Brazil's biggest city, a city with the highest level of economic development in this country, a city where the state that calls itself ultra-developed, but unfortunately there are human rights violations right there in the downtown area of São Paulo, just in front of us. So this is not a theoretical conversation of a possibility of human rights violation, a theoretical conversation that is very complex. No, this is very simple. It's easy and simple to violate human rights. And it's very simple to violate human rights in some countries where you're able to treat people as if they were animals and not human beings. Why? Because a lack of democracy in a country occurs when you remove the reasoning qualities or the culture of that population, when you do not preserve the ability for your people to reason, for example, with education, with culture, with different, for example, viewpoints and discussions and education. We're at the end stage of an electoral campaign right now. I'd like to remind you of São Paulo. In São Paulo, we had a recent debate that became a meme in all of the world. There was a debate that raised eyebrows. If you were able to watch the newscast in the United States or France, you know that every night and every day there's discussion on a certain politician, right-leaning, that debates for 40 minutes and is not even there. But in those countries, they do not lose out on their ability of discussing and of living socially. Unfortunately, in Brazil, there's still a lot of complexity involved. The tribunals here in Brazil, the electoral courts suffer from many accusations of votes of vote purchasing, of buying votes in elections, things that we wouldn't find possible in 2024, but still occur frequently. So the possibility for the creation of International Constitutional Court has a major challenge, which is to have a new, very specific jurisdiction. We've seen this in crimes against humanity, for example. We already have them adequately treated in other environments. We have these discussions, such as the discussion on democracy in Venezuela that is being discussed in the International Criminal Court. We have other possibilities but it is still possible today to create an international constitutional court specifically to deal with the violation of democracy. I do believe that we have a long path to tread. It's ever more frequent for us to have a democratic debate that seems like it's more stress. It seems like we have less democracy in a number of countries, but I do hope that we can discuss this here and that this may become a subject. As Vinicius commented, when we've organized about 10 years ago a summer school in Siena on democracy and development. It's been 10 years that democracy under development it's been 10 years, but the subject is still very updated and current. I do hope that Appellate Court Judge Marco in the 17th Congress, I hope that in 17 years I'm back here. I hope that democracy is no longer a very relevant subject. We have a big level. We hope that in the future we'll have democratic rights established, consolidated, implemented, not only in our country, but in all countries. I do hope that this will be a milestone, a pillar of our human development, a consolidated pillar. So I thank you very much for participation here. A wonderful afternoon, all of you. So we have received some questions regarding, even during both lectures, that of Professor George and that of Professor Thiago. In the first moment, I'd like to mention it was an interesting speech by Dr. Thiago about of the reason behind the why should we have a constitutional court. There are many students here from our institutions here, as well as other private education systems. And when we look at their resumes, we see we used to have both public and private international rights. Now we just have international rights. And Dr. George Andropoulos, in your international experience, why do students nowadays do they study this discipline? Do they study international tribunals? Because in many cases, it seems that the cases are very distant. We don't feel really the effects, direct effects, immediate effects of a genocide such as the one now occurring. What is the impact to Brazil? Why should Brazil be following these discussions carefully? This is a work that I'd like to ask you if you could have a question, if you could answer this to the public. But the second question as well is, in Brazil we have indigenous populations, native populations that are constantly suffering from violations and attacks and violations of their rights, especially connected to land, to health. During Brazil's COVID pandemic, we went through a very serious phase where the native population of this country was pretty much abandoned regarding its rights to health. So in light of this situation, therefore, where the native population, indigenous population in Brazil, in light of the situation that it's currently going through, in your vision, Sir, could this be characterized as a crime of genocide? So in the first moment, these are the two questions initially for Dr. George Andropoulos, and if later Professor Thiago also wants to talk about Brazil's indigenous population or native, would that be considered, their treatment, would that be considered a crime of genocide? Professors? Professor George, please.
Thank you very much for these very important questions. The first one, both, we can talk for hours about that, but we don't. So I will try to be brief. Why should we care about what these mechanisms do? And in particular, why should students care about this? There are several reasons. And here are some of them. First of all, it is kind of in these mechanisms, despite their shortcomings, despite their difficulties, despite the delays in adjudicating, they are platforms in which very important discussions take place about norms, and norms, international human rights norms and international humanitarian norms that bind us as an international community. Okay, so first reason why we should care about it is because we are talking about issues, conditions, situations, and values at stake that make us who we are. Okay? And I would like on this to bring an example, if I may, from the United States. When there was a discussion in Congress about this issue did not deal with genocide, but it dealt with violations that relate to war crimes, serious violations of international human rights. When there was a debate about whether Congress should adopt the Detainee Treatment Act, the argument of those that is more humane conditions for those that were being detained under the so-called global war on terror, which is another term that I have problems with, but I will not get into this now. There were some people from the right, the Republican right, that were arguing we should not give them minimum humanitarian protection, the detainees that come from Al-Qaeda or from the Taliban, because these people don't observe these norms. These people basically are, and very nasty terms were used by some lawmakers, they are animals, they are savages, and so on and so forth. And what was interesting is that from the Republican Party, the very same party, John McCain, the late John McCain, who was a presidential candidate in 2008 and had gone through the brutal experience of being tortured when he was captive of the Vietnamese during the Vietnam War, said that I personally support this legislation and we should treat them humanely, referring to common Article 3 of the Geneva Convention should apply. Not because on the logic of what we should do to them, what they do to us, but on the basis, because if we use that logic, we will not even be having this conversation. We should be taking seriously our international obligation because it says something about who we are as human beings. Okay? Who we are as human beings. So it depends how we want to perceive ourselves. If we want to perceive ourselves as human beings that take seriously this norm, irrespective of those with whom we may have arguments, wars, and dispute, then we need to take this seriously, because if we don't subscribe to this logic, there is only one path. The path, the downward trade to continuous savagery, dehumanization of the opponent, and so on and so forth. So that's one important reason why we should care about what was happening in these tribunals. Second, because in the society that are affected by these atrocities, decisions or even deliberations in these tribunals are picked up by civil society actors in their efforts to mobilize their constituencies in order to ensure that such atrocities do not recur in the future. So the idea here is not, one aspect is, of course, because of who we are, which for me is very important. The second thing is because these discussions, these deliberations, even if they do not reach the desired conclusion, or even if in order to reach the desired conclusion we have to wait years and years, in the meantime, they give opportunities to civil society actors to push for legislative reforms, to push for educational initiatives in their countries, to push for extra measures of protection for the most vulnerable, to ensure that their societies do not again descend in the level of inhumanity that they had witnessed. There are other reasons, of course, but I will stop on these two. Now, concerning the indigenous peoples. The indigenous people is a very interesting topic and merits a lot of discussion, because indigenous peoples have been brutalized in all parts of the world in which they exist. By the way, yesterday we had the speaker on the Inter-American human rights system, and I would like to add a footnote to what this person said, that the Inter-American system have been a leader among regional human rights system in addressing indigenous people's rights. Maybe not always to the satisfaction of indigenous communities, not always reaching the desired results, but it has been on the radar screen of the organs of the American system of human rights, the Inter-American system, both the Commission and the Court, much more than in any of the other regional human rights instruments. Now, is it a situation of genocide? Some people have argued that. Of course, we don't have a determination by a legal body to that effect. Having said that, I would argue personally that a lot of the persecution of indigenous activists, the targeting of environmental activists, efforts to silence or suppress their mobilization for different, definitely will fall under the possible rubric of crimes against humanity. And having said that, it doesn't mean that this is a better, kinder, gentler crime, as I have said before, because crimes against humanity is very serious indeed in its own right. Thank you.
Bom, nós temos aqui.
Well, we do have here about 6 questions, but in reality, all of them have the same topic, actually. They address the same issue. I'll try to wrap them up and sum them up, actually, in the interest of time. All of these 6 questions that came to us have mentioned war between Russia and the Ukraine, and the questions have to do with the same issue. How come we don't have the Penal International Tribunal or an International Court of Justice? Why are they not intervening in the war in the Ukraine, Russian war on Ukraine? And would there be a measure, international measure, on the part of these courts that could interfere not only to mitigate or even perhaps to put an end to the crimes that are being committed in the course of this war. All of these questions have to do, and they've been directed to Dr. George Andropoulos. Dr. George, please, you have the floor.
Thank you. I feel I am on the defendant's stage here with all these questions coming one after another. No, joking. Thank you very much for these questions. Wow, another long topic. I will try to give a brief answer, if I may, because we're running out of time. First of all, have in mind that courts cannot intervene to stop conflicts. They don't have any enforcement power. What the International Court of Justice can do, it can issue a ruling, and then if the party in whose favor the ruling is, if they see that that ruling is not being observed, they can appeal to the Security Council to request that the Security Council enforces the court's decision, the International Court of Justice. Now, both the International Court of Justice and the International Criminal Court have handled cases relating to the Russian conflict. Very quickly, when it comes to the International Court of Justice, the Ukraine has sought provisional measures which have been granted and has asked the court to and one of the provisional measures is for Russia to cease and desist in its military operations against Ukraine. What did Russia did? It ignored it. Now, what is the only option that Ukraine has until the ICJ decides on the merits of the case that will take probably 8 to 10 years from now? Anyhow, it can appeal to the Security Council to enforce the decision. Well, here comes the problem. Russia is a permanent member of the Security Council, so it will veto any action that the Security Council will try to take. So don't expect any protection through this process at this point, unfortunately. Now, concerning the International Criminal Court, the prosecutor of the ICC has issued arrest warrant both against Putin and against Alexeyevna, who is the Commissioner for Human Rights in Russia, for the deportation of children and the transfer of children from Ukraine to the Russian Federation. I thought, in my view, that was a very smart move on the part of the prosecutor, because obviously Russia got very angry about that and denounced the prosecutor. Actually, the prosecutor has been denounced by Russia for issuing the indictment against Putin and Alexeyevna, has been denounced by Israel and the US for issuing the arrest warrant against Netanyahu and Gallant. Of course, the US ignored conveniently the fact that he also issued arrest warrants against 3 Hamas leaders. But in my view, if somebody is criticized by Israel, by the United States, and by Russia, means they are doing a damn good job. And the bottom line is that it was a very smart move on the part of the prosecutor, because although Russia was very quick to say this is a politically motivated, he chose very carefully the topic, the issue area to issue the indictment: children, the protection of children. Because who could argue with the fact that children need to be protected? You can argue if, for example, you drop a bomb in a place that kills civilians, you can always say that's not a war crime, that was collateral damage. You can argue whether if you are targeting a refugee camp that terrorists or fighters were hiding in, it was a legitimate target. You cannot make a credible argument to justify if you are deporting children. So it was a very smart move on the part of Khan. And by the way, in my view, he's doing a damn good job as a prosecutor at the moment. Thank you.
Bom,
Well, I think we don't have any other questions at this time. I would like to, are we going straight to the following panel? Are we taking a break? Dr. Tarsus, should we break for a few minutes? Well, then, I would like to thank profusely Dr. George Andropoulos and Professor Thiago Matsushita for their remarks. Two distinguished experts. We've had a very, very interesting panel. And again, thank you, Dr. Vinicius Marcos and Dr. George and Dr. Thiago. Thank you so much for taking part in this brilliant panel. A round of applause for both speakers. Thank you very much for being with us, and we will give out the Medal of Academic Merit of ESMAT, Dr. Feliciano Machado Braga, to Dr. George Andropoulos. To award him the medal, we would like to invite on stage Appellate Judge Marcos Villas-Boas, General Director of the School of Magistrates of Tocantins. And now we'll take a picture. I would like to invite Appellate Judge Marcos Villas-Boas to issue certificates. All right, let's have a round of applause for our distinguished speakers. Ladies and gentlemen, before announcing the next panel, I'd like to remind you that the next panelists will will give out copies of this book, Cyber Resilience, Dominion and Security Strategy, Artificial Intelligence, Generative and Artificial Intelligence. 70 reais is the value of the book. You can purchase it through the QR code that we will put on the screen right there on the sides of the stage. And again, all the journalistic coverage of our event, you will find it in ISMET at TJTO.br and our Instagram at ISMET. Well, ladies and gentlemen, to mediate the next panel, to moderate the next panel, I'd like to invite Appellate Judge Marcos Villas-Boas, please.
Appellate Court Judge Marco Villas-Boas, I'd like to invite him up to stage as a moderator. As the moderator. Just a small note, we're waiting for one of the panelists, so we'll ask you for a 10-minute, we'll give you a 10-minute interval for some refreshments. Thank you, we'll be back in 10 minutes, thanks. I would like to read the resume of our panelists. Ana Carla Liacherian. She's a law professor at USP. She's part of the faculty of financial legal. She's a master and a PhD. USP, she's a lawyer with practical experience in public rights, LGPD, new technologies, is smart cities. She coordinates the research group USP Smart Cities DR, and she's specialized in public policies and audits at ESP USP and FEA USP. She's an author and acted as a committee as coordinator of the Innovative Culture. Rui Barbosa, she was a counselor and the director of human rights at USP. We also have here with us Luciano Vieiro Araújo, master's in computer science at USP. He has a PhD in biocomputer science at USP. He's a professor, PhD professor associated to the art schools, the School of Art, Sciences, and Humanities at USP. He is a reviewer of a project for encouragement of the Research Foundation of the State of São Paulo. He's a reviewer at the International Journal of Medical Informatics. He's very active in the subject areas modeling of complex data, big data, data science, learned from data, and data analysis low cycle. We also have Dr. Lauro Ishikawa. He has a master's in law at the Catholic University of São Paulo. He's a PhD. He has a PhD from Salamanca University in Spain. He's a professor of the university. He's coordinator of the legal program at Unialfa FADISP. He has a master's. He is a lawyer as well in São Paulo. So, after some stumbling, let me please yield the word to Appellate Court Judge Marco Villas Boas. Good afternoon to everyone present. I'd like to acknowledge the panelists, greet them. We can see that this is a very select roundtable, highly trained, highly prepared, in a moment that is the current moment, which intersects all of the most important and innovative technologies as well as disruptive, and its intersection of these disruptive technologies with human rights. And in our next International Congress on Human Rights, we'll be speaking about the impact of AI in the human rights systems of protection in people's lives, in workplace, in industry, in the judiciary. We are basically designing together with USP, together with the John Jay College in New York, with Microsoft. We will be having a joint event, an event which will be held jointly with Brazil and the United States. It will be a wonderful event with excellent results. But let's get started right now with a very high interest subject right now. As I've mentioned, we've advanced in the use of AI in the judiciary. The National Justice Council has sought to advance in this aspect. Under the presidency of Minister Luiz Roberto Barroso, he's advanced that the National Justice Court has started regulating, as Congress is about to adopt the regulation of AI in Brazil, in a congressional committee whose president is Minister Vilas Boas Cueva, who was here a few days ago with us. dealing with subjects involving health, but also involve the use of modern technologies. So, in the Tocantins judiciary, starting in August 2023, we've made advances. When we, in August 2023, we signed an agreement with the University of São Paulo. We had the presence of the tribunal, of the courts, our executive director, Ana Beatriz Preto, together with Professor Carla Lacheriani and Professor Luciano Barbosa, and the director of, and also representatives, other representatives of the University of São Paulo, and of the magistrates associations of the state of São Paulo, appellate court judges, and it was very significant, and we were able to advance in the creation of a proposal, a project, which is called the OBIS project, which may symbolize best our current concern with the use of AI. Horus is a Egyptian goddess or god, and its fight. He was fighting against Sept, which was the god of evil, and he loses the left eye and is replaced by a serpent. And the symbology, Egyptian mythology says that highlights the power of the serpents to symbolize the divine power that would exist from the symbology. The serpent returns to Horus a special vision, a vision that is transcendent, that is a moon vision, which would amplify, increase the vision, and would allow him to continue the struggle against evil. And that is the lunar eye. And we acknowledge to the serpent what we now agree would be the potential vision, or rather AI. But AI depends on the solar eye, on the vision solar, on the solar eye, which is the human eye. Meaning one does not work without another. AI must be dependent on the human eye, monitored and supervised by the human eye. And I do believe this is the biggest challenge of the judiciary at this very moment, because we cannot miss out on this historical scientific advance. We must surf the disruptive and innovative technologies, but we must also assure compliance with fundamental rights. We must have the eye monitor everything. All of this use. AI must be used towards benefiting human dignity and not against human dignity. If it's damaging, it must be regulated and vetoed. And we must evidently we'll have I'm sure the big tech sectors will help out, industry, academia, the judiciary, the institutions will all help us. Everyone who works with the courts and the government systems will have to work together so that AI will promote the good of will promote the benefit of humanity and not destruct humanity. It's with these initial words that I'd like to yield the word to Professor Ana Carla Bliacherian, who is a very well-known name in this intersection between computer science, engineering, governance and digital transformation. She is highly capable, representing the University of São Paulo, and she represents ably the University of São Paulo in international congresses in other locations in Brazil, discussing in the National Justice Council with other Brazilian technicians the project that we're developing jointly, and I'm sure we'll have a wonderful lecture on this subject. Professor, thank you. Good afternoon. Good afternoon to everyone. Allow me, appellate court judge, to speak while standing up, and I'd like to invite Professor Luciano so that we can do this together. Professor Luciano, I'm sure you all are very aware of him because of the resume, his curriculum, but you can be sure Professor Luciano was one of the gentlemen that worked in scientific research during COVID and that avoided thousands of deaths in Brazil. His research, his advanced research, helped us develop techniques, vaccines, and medication to fight the coronavirus. So the services he has rendered to society, but not only to society, but humanity, are very important. Professor Luciano Araújo.
Boa tarde a todos e todas
Good
aqui
afternoon
presentes,
to everyone
valentes que
here.
ficaram para o
So the
último
courageous that are here
painel.
for this last
Haja
panel,
valentia, né? Ficaram
there's a lot of
conosco.
courage here.
Boa tarde.
Good afternoon. It's always wonderful to be here in Palmas and to be able to witness so many friends here. Our biggest warmth is not the one outside, but the human warmth that is present in this audience. And this meshes very well with this theme in human rights. You guys know how to take care of people, and that is very
Sabe o que a gente
inspiring
fez
for all
hoje
of
pela
us.
manhã,
Do you know what we did this morning?
nessa terra linda?
In this beautiful land of
Quem
yours,
adivinhar o que a gente fez hoje pela
if you
manhã
can
ganha um
guess,
livro autografado.
you'll win out on an autographed copy of our
Ganhou
book.
um livro.
She won. I'm sorry, the interpreter could not understand what was said off mic.
Agora eu desafio você a adivinhar os
The challenge is to you have to guess the next numbers in the winning lottery ticket.
Acordamos bem cedinho
So
hoje,
we woke
muito
up
cedinho,
very early
pra
this morning
merecer a bênção de um banho refrescante
to
daquele de uma natureza
have a
virgem,
refreshing bath
encantadora.
of
Foi
virgin
muito bom,
nature
chegamos aqui
in the
bem
river.
revigorados.
And we reached that,
Então, eu
we've
sou a
arrived
professora
here
Carla
reinvigorated.
Bachanier, professora de Direito,
So I'm
curso de Gestão de
Carla
Políticas Públicas
Bachanier.
da
I
Universidade
am
de São Paulo.
I am a professor
Junto com o
of
professor
law.
Luciano,
Together with Professor
coordenamos
Luciano,
um
we
grupo de
coordinate a
pesquisas
research
chamado
group at
Smart
USP
Cities
called
BR.
Smart Cities
Esse grupo de
BR for Brazil.
pesquisas, a gente
In this
trabalha
research
temas
group, we
que
work
estão
on
na zona de
subjects
interseção,
that are in the intersection
tecnologia,
zone
direito
between
e
technology,
políticas públicas.
law,
No meio
and
dessa esquina,
public
dessas
policies.
três grandes áreas
And
que se
in
encontram,
this area,
está
this
tema
convergence area,
importantíssimo que afeta
there's a very
todos
important
vocês
subject
que
that affects
trabalham
all
no
of you
judiciário,
who
que é
work with the
exatamente a
judiciary, which is
transformação
exactly
digital
the digital
do judiciário,
transformation
da
of the
entrega, da
judiciary branch,
prestação
of the delivery
jurisdicional.
and of
E para
the
nós
legal
aqui,
provision
estar no
of
auditório
services,
desse evento,
and for us to
tantos
be here at an
jovens
auditorium witnessing
assistindo
so
a
many
palestra,
youngsters
dá
watching this
tanto de
lecture is
esperança de
really
futuro que está sendo
for us
construído hoje
inspiring
e aqui para o
and
Poder
hopeful for the
Judiciário.
future that is
Além
being
dos que
built
nos
today
assistem
here. In addition to
remotamente, né?
those
Grande
who are
abraço para todos que estão
watching remotely,
remotamente
I'd
nos assistindo
really
agora
I'd
nesse
like
evento
to
que
very
é
much
transmitido.
acknowledge their
Junto com
presence
o
that is
professor
being
Júlio Caram, que é da
streamed,
engenharia,
together
a
with
professora
Professor Júlio
Fátima
Caram,
Nunes, que é
who's
da
from
ciência da
engineering,
computação,
Professor
o professor
Fátima
Luciano,
Nunes
que é da
from
ciência
computer
da
science,
computação.
and Professor
A
Luciano
gente
from
tem
computer science.
navegado
We have
nessas
together
fronteiras, mas uma navegação que vai além da navegação
navigated
teórica.
throughout
A
these
gente
frontiers, but
tem
we've gone beyond the
experimentado.
theoretical
E nesse
navigation. We've done
experimentalismo, aqui na
experiments.
Tribunal
And
de
with, this,
Justiça
with
do
these
Tocantins,
experiments
a
here
gente
with the State
encontrou
Court of
espaço
Tocantins, here we found
espetacular
a
para
wonderful
inovação.
space for
Então,
innovation.
deixar aqui, em nome da
So I would
Universidade de
like
São Paulo,
to,
o
on
nosso
behalf of the University of São Paulo,
abraço, mas não só
I
o
would
nosso
like
abraço, a nossa
to
admiração a este tribunal
acknowledge
que
our
abriu as suas
admiration
portas
of this state
para
court
pensar,
that opened its
repensar
doors
e
for us
testar
to
novas
think,
formas de
rethink, and
prestar
test
a
new
jurisdição
manners
de uma
of
forma
providing
célere,
legal
mas sem abrir
services
mão
in
de
a
ética,
rapid
direitos fundamentais,
manner, but without
privacidade,
sacrificing
respeito à
ethics,
liberdade,
human rights,
transparência,
transparency,
deixando que o juiz
allowing
seja
judges
ainda aquele
to
que decide
be
e não
to still be the one who decides,
fazendo
but
com
not
que os
only that,
juízes
having
possam
judges
voltar a ter o tempo para
have
olhar as
allowing judges to
pessoas
have
do
time
processo,
to look and to
além
analyze
de
individuals
e serem aquilo que a gente aprende
and
na
to
faculdade de
be
Direito. Eu tô
that
vendo
which we
muitos
learn
jovens
during
aqui
law
que
school. We
imaginam
can
quem
see
são
many
os
youngsters here
estudantes.
who are
Que a
still
gente
who I could
aprende
imagine are still
quando fala
students.
da
But what do
língua?
we
O
learn when we
poder
talk about
judiciário é
the lady?
pacificador
That the
social,
judiciary branch
que
is
ele
a social
chama para si,
pacifier,
né,
that it
o
calls
dever
to
de
itself
levar
the
a
duty
santo
of analyze,
Porque duas pessoas se contrapõem, ele chama para si
because
a
you have two individuals that
responsabilidade de dar a
are
solução
in
mais
conflict,
justa
it calls to
possível
itself
dentro
the
dos
possibility
parâmetros
of
da
providing
lei.
the solution
Quando o
as the
judiciário
more
tem
just possible
83
within the
milhões de
parameters of the law.
processos a serem
Our judiciary has
julgados,
83 million
quer
court
dizer
cases that
que
are still
o juiz
pending,
não tem tido
but
esse
that
tempo
means that judges
necessário
have
para
not
olhar
have
para as pessoas e
the
para nós.
time needed to
E
look
que os
at
servidores
individuals
muitas
themselves.
vezes correm
And
para
public
serem
servants,
curadores de
they struggle to
processos
be
e
curators of the
não para solucionar
processes, and not to solve
Essa
the
lógica da
processes themselves.
superjudicialização
This
tem raízes próprias no direito brasileiro.
overjudicialization, which is
Ela
a
tem sido
mark of
tentada ser
Brazil's
combatida através de
judiciary.
alterações
We've tried to
processuais,
combat
súmulas
this
vinculantes,
with
temas, julgamentos de
processes,
massa, mas
with
isso tem
alterations,
resolvido?
with
Não,
precedent,
melhora, mas
uses
não
of
tem sido
precedents.
capaz
Has
de
this solved it?
resolver
It has
a
improved,
enxurrada
but
de
it has not been
questões,
able to deal
porque
with the
existem
huge
conflitos
number of new
latentes e
cases,
vigentes na
because there are
sociedade.
conflicts
Esses conflitos,
in
parte
society.
deles são
And these conflicts,
conflitos
a
reais,
part of them are
e
real
parte
life
deles são
conflicts, and
conflitos
part
não
of them
reais,
are
mas que
conflicts
se
that are not real,
aproveitam da
but
lentidão
they take
judicial
advantage
para
of
se
the
perpetuar.
morosity of our
Como é que a gente
branch
enfrenta isso?
to
Contratando mais juízes? Contratando mais
to do this.
servidores?
So how do we
Fazendo
face
grandes
this? Should we hire more
alterações
judges?
processuais? O
Should we
judiciário
make
vem
big
tentando
changes
essas
in
abordagens ao longo
processes?
do tempo. E elas são
The judiciary
importantes,
branch has
mas
tried
elas
to do
são
some of this. They're important,
suficientes
but are
para
they
que a gente
sufficient
tenha, de
so that we
fato,
can
um
have, in
judiciário
fact,
ativo,
an
ágil,
active,
eficiente,
agile,
que
and
alcance
efficient
alívio?
judiciary
Não.
that
E não
renders
havia
its
até
decisions
então
correctly? No.
nenhuma
There
tecnologia
wasn't up until
disruptiva
now
que
any
pudesse dar ao Poder
disruptive
Judiciário
technology that could provide the
poder
judiciary
que ele
with
ainda
a
não
power
tinha
that it still did not
de
have
grande processamento
of
de
which would
dados.
be of data
Aí o senhor vai
processing,
dizer,
a
mas
big quantity of
professora, eu já
processing
ouvi
of
falar
data.
no
But
Vitor,
professors,
já ouvi falar no
professor, I've heard
Sócrates,
already of
tem
Socrates
de
and Vitor.
robôs
There are a number of
baseados
robots,
em
computer
inteligência
robots based
artificial.
on
É mesmo isso,
AI.
professor?
I
Eu
heard
ouvi
about this,
ministros falando
professor.
sobre
I've
isso.
heard
E
ministers
esses
speaking
robôs
of
têm a
this.
missão
And
exatamente
these
de
robots
trazer
are exactly that. They have the
agilidade para
mission
o
of
Poder
bringing
Judiciário.
agility to the
Por que não
judiciary.
resolveram,
So
professor
why did they
Luciano?
not solve the issue, Professor Luciano?
Bom,
Good question.
essas
Well,
tecnologias,
these
elas são
technologies
baseadas,
are based,
essas soluções são baseadas
these
na
solutions are
tecnologia
based
que
on a
é
technology
pré-regenerativa, a gente vai falar
that
daqui a
is
pouco sobre isso.
pre-regenerative, if you will. We'll
Elas
speak more about this
conseguiram
later on.
fazer melhor,
They brought what they
tem ótimos
could do
resultados,
best
mas
in a certain
resultados
moment.
com algumas
Sure, they had
características,
results, but some results that had some limitations, which is what we want to talk about over here. One of the major challenges that we have today is that this is a technology that is new.
Nós estamos falando aí pouco mais
We're
aí de
speaking now in terms of
23, quase 2 anos,
2 years, 23
né,
months
dessa tecnologia
of having
generativa.
this
No conhecimento
regenerative
das pessoas,
technology
na área técnica,
used
já
in human
existia
knowledge.
já há alguns
In
anos,
the
mas bem
technical area,
limitado. Então, é
it
isso que a gente
already
vai
existed,
conversar
but
com
in a limited
vocês,
fashion. But
para
what we
pensar
want to
esses
talk to you about
desafios
is to think
e os
about these
desafios também na
challenges
perspectiva
and
da
challenges
valorização do
regarding
indivíduo,
the
do ser humano,
perspective
tá?
of
Que é um
valuing the
aspecto
human
aqui
life,
presente,
the
né? A gente
individual, which
trouxe
is
uma
someone,
rápida definição
which is what you
aqui
guys
do
are
que
here. So
inteligência
we have a
artificial,
quick
é uma
definition of what
simulação das
AI is.
habilidades
It's a
humanas. Então,
simulation
ela
of
vai
human
simular o que
abilities.
nós
So they will be
fazemos.
simulating
Então, a
what
gente
we
começa a
do.
pensar por
So we
aqui.
start
O
thinking
que a
in
gente
this
faz?
manner. What is it
Nós,
that we
como
do?
humanos, o
As
que nós
humans, what do
fazemos?
we do?
Fazemos coisas boas,
We do good
coisas
things,
não tão boas,
not so good
Acertamos.
things.
acertamos.
We get
Erramos.
some things
Às
right,
vezes
we
nem
get other
sabemos
things
se estamos
wrong,
acertando
and
ou
we're
errando.
not
Mas
always
sim,
certain if we're right
essa
or wrong.
tecnologia vai trazer um
This
pouco
technology
disso
will
também.
provide
Perceba
this
que
as
vai
well, in
mudando
part.
da computação que a
Notice
gente tinha antes,
this
que
is
era uma
no
computação um pouco
longer
mais
the computer science
exata,
we had in the past, which was
precisa,
more exact,
que
more
era zero,
precise,
né?
which
Ou
was
certo ou errado.
unitary,
Aqui tem
which
uma
was 0
margem
or 1,
para o
right or
que
wrong.
nós
Here we
humanos
have
podemos
a
aceitar, né?
margin for what would be
Vocês
acceptable
erram, por
to
exemplo.
humans. Do you guys make
Alguém aqui
mistakes?
erra?
Does
Não,
someone here
todo
make
mundo
mistakes?
aqui não
No,
erra.
nobody makes any
Né? E
mistakes.
vocês conseguem sobreviver com
And
erro
are you still able to
até hoje,
survive
né? Eu tô
amidst
certo.
mistakes?
Uma
A gente
pergunta,
Yes.
né? O judiciário
A
erra?
question. Does the
Eu acho que não
judiciary
erra,
make
não. Erra.
mistakes?
Existe erro
I don't think
judicial?
so, right? Do they?
O
Are there
judiciário
mistakes in the
pode até errar, mas
judiciary?
o juiz não erra, não.
They may make
Juiz
mistakes, but
erra.
not the judges. Do the judges
Juiz
make
erra.
mistakes? The
Não.
judges? Never?
Será que existe alguém preso hoje
Is
no
there
sistema
someone who is
prisional
detained
brasileiro
today
pelo erro
in Brazil's prison system, is someone detained because of a judiciary
Como é que a gente
mistake?
vive com isso? A gente
How
acaba
do
com o poder
we
judiciário, já que
coexist
tem
with
erro?
this? Do we Do we sunset the judiciary
Algoritmos
because there are
podem
mistakes?
errar?
Can algorithms make
É
mistakes?
uma pergunta que a gente deixa
That
aqui
is a
para vocês
question
e
that
até
we
o final
leave
da
to
palestra a
you.
gente vai
Up until
construir uma
at the
resposta
end of the
conjuntamente.
by the end of the lecture, we'll
E
we'll have an
tolerável?
answer.
Perguntas que
Is
eu vou
it
fazer para vocês
tolerable? These are
pensarem enquanto a
questions that
gente
I'm
vai
asking you
avançando.
for you to think while we advance.
tolerável
Is it
lidar com
tolerable to
algoritmo no
deal
Poder Judiciário
with an
aqui?
algorithm
Primeiro, eles erram.
in the judicial branch
Segundo,
that may make
é
mistakes?
tolerável conviver
So they
dentro do
make
sistema
mistakes,
judicial
the
com um
algorithms.
algoritmo que
Is it tolerable to coexist in the judiciary with an algorithm that makes mistakes? Or how can we coexist with these failures or with these rates of error? That's what we think about. We must think about that. AI allows machines to act, or not think, but act at least, in a way that is similar to humans. So everything that we do to deal with these limitations, it could perhaps be interesting for us to deal with this technology. Why are we here today speaking about something new? You've told me about, I've heard about your thinking about the robots that work in the judiciary, but I ask you, are they solving our problems with the excess of pending court cases, with the delays in the rendering judgment? No. So what has occurred that is different that we're bringing to you today that you haven't heard before is that we had pre-regenerative systems of AI, or AI that was pre-regenerative. It has a reasonable predictive ability. It can collect standards from keywords. It can provide us with information on some indicators, but it is not able to simulate steps or stages of our work as human beings. Previous industrial revolutions were very capable of replacing our arms, but this technological revolution that we're going through right now, with the massive use of regenerative AI, it is capable of acting as we act. They are able to replace us in certain activities that previously depended on our own mental abilities. Not only our arms. This means that mental repetitive work, or even complex mental work, repetitive work, can be undertaken with the use of regenerative AI. What a magistrate does, the act of rendering judgment, is it a complex mental process? Yes. Can it be supported by the massive use of regenerative AI? Yes. Can he be replaced by the use of AI? In a democratic country, I would answer no. And we'll see some of the process principles, but in an autocratic country, it is already being used to replace the figure of a magistrate. So when we speak about the use of generative AI use by the judiciary, we're speaking about 3 levels of use. A first level is about comparing documents and checking documents. A second level, which is about text reading, comparison of texts, creating minutes, helping the work of the magistrate. And the third level is the replacement of the magistrates with the application, an almost mathematical application of an understanding of a jurisprudence or of a law. How are we working in this tribunal? In this tribunal, we're working the first and second level, keeping the magistrate as a central point of the judgment of a case. So thinking about this perspective and now trying to understand this technology and how can we use this, and the use of this timeline shows this new technology and the separation. What is pre-generative with generative? Here we have a change in the paradigm, so it's difficult to understand what is coming immediately afterwards, which is why it's so important to think about this. We transition from the development of solutions where, first of all, it was all about standardization. Everyone will do it the same way. So the systems that we're accustomed to use, You have your cell phones, for example. You may think, let's find a standard or a pattern. And when you find this pattern, everyone accepts some differences, and at the end of the day, no one accepts anything. Now we're heading to technology that would allow for a customization, will help us help the individual. In the judiciary, we're talking about simple language to overcome the difficulties of the judgments. What is simple? It's simple to whom? Each person has a challenge. For example, someone who's illiterate needs maybe an audio. You may need audio for him. For someone who works who does not work in the judiciary, you may simplify some questions. But each challenge, this technology allows for this. And when you're thinking about this, this is the importance of speaking about that. We'll be bringing you the perspective that must be dealt with by AI in the solutions that we will be building. So that is a role that involves us as a whole. Professor Luciano, do judges judge in the same manner every case? Do appellate court judges judge in the same way? Other cases? Do court panels judge the same way? No. So how can we do this if we need to find a pattern or standardize? If we need to standardize, we'll continue doing the tasks that everyone agrees with. For example, the documents have arrived. These are systems, a flow, these controls of flows, that electronic workflow. These systems all tribunals have, but to decide on what will be done based on the content that we haven't had. What we're saying is that generative AI supporting the magistrate's office is able to absorb. Once trained, it's able to absorb the way that magistrate writes, the terms he uses, the historic understanding that he has on that subject, and the way that he may want that the sentence, the manner or the wording of the sentence. That means that the same system will allow in the next, with another judge's office, will allow a text and a different delivery for another courthouse. This is a standardization that this technology brings in a disruptive manner to the judicial branch. But can we also use it to standardize things? Sure. It could be used to standardize, and it can also be used to differentiate. In democratic justice models, what is imaginable is that it will be used for customizing, because it's up, who should decide in a democratic justice model? It's up to the magistrate or the judge to decide with independence, and not having a standardized algorithm, and perhaps in the future an overriding direction. But how about precedents? Don't precedents demand that a magistrate judge in a certain manner? We're speaking about what is obligatory within the limits of the law. And this limit of the law is highly discussed using different theses, antitheses within the tribunals themselves, so that we can reach an understanding. And the tribunals, the precedents, we have precedent decisions we have precedents issued by upper courts that after years are changed somewhat when new facts appear, and the upper tribunals then understand it differently. So it's not submission to the magistrate, but it's an issue of rationalizing the flow of the judiciary process in a country where the judicial system is highly complex. Brazil's judicial system is not a simple one. It is a highly complex judicial system.
we have had models of generative artificial intelligence to take care of these features. Most of you know artificial intelligence, generative AI as ChatGPT, Gemini, Copilot, and other products, cloud, and so many other specializations of this model. But people sometimes think that this is the only approach, yet it's not. That's why we've been trying to work with on solutions that we've come up with. We keep asking, what are the possible models? One of them is this model via chat. But it's wonderful before this model to use artificial intelligence. You have to be an expert on the topic. It was difficult. It needed a special server infrastructure, something very complex. Now you get the cell phone, you write, you talk, and you get the answer. If the answer is not what you were asking for, you ask them to improve the answer, and they'll give you a better answer if you're not satisfied with the original answer. This approach with the chat, we call it a passive approach, in which it depends on the action of the individual and the ability to ask. And it's very interesting for scenarios in which you need to explore contents, especially new contents. But when the content is repetitive, for example, even despite the content of a legal lawsuit, for example, even though it has varied contents, different parts, articles in the law that are different, the structure of that document is very similar. And when you go to the figures that our dear professor was talking about, thousands of active lawsuits, and 2.2 million lawsuits arriving at the legal branch of government all the time, it's difficult to work on them individually, one by one. So we have suggested this active approach, which will deal with the volume of data, documents, to allow a scale analysis, complex rules to support the individual and the lawsuit, and the magistrate too, the judge, both the judge and the servant and the civil servant will show them what we have found, assessing all the jurisprudences and articles quoted in support of the actions they'll take. Everything's done actively, showing results, practical outcomes that they can be used. Integrating them into existing systems. This integration is possible with automatic generation of minutes and documents that are routinely done in the judiciary branch. And what have we written down here? What we have included here, when you do a chat approach or artificial intelligence, generative AI, passive AI, as we have called it, what you do have is a dissemination of rework. Many people, several people from that department and that court or tribunal will process the same documents and even ask repetitive questions of the chat, thereby generating increase of data processing. In addition to the cost that goes up, you have the lack of sustainability. So you see, when we adopt as a standard the chat model, we're adopting as a model a standard, a chain of work that produces rework. And many people will ask, what are the parts? What's the cause of the request? What's the object? What article in the law? And each one of them will be asking to do part of the flow. When you have a generative and active artificial intelligence model, generative model, they'll process all the blocks in the lawsuit, and they'll check the information which will be reiteratedly asked, and they'll process it just once, thereby ensuring speed, savings, because you don't have the processing costs of artificial intelligence every time you use it, and it generates less variability of results. That is a problem in the judiciary branch, and the use of generative AI in the model, in the model of the passive model, it is highly dependent upon the user and the ability that he or she has to ask the adequate question in the right way, so that they'll be providing him or her with an answer that's as close as possible statistically to what you need or want. And the chat model of variability is very large because it depends heavily on the human being. And the artificial intelligence generative model that's active, which is the one that we advocate, and this model that we've created, it generates a greater control of results, and that generates something that to us, jurists, is extremely important. It's fundamental. That's some legal security. Well, in this universe of artificial intelligence, generative artificial intelligence, the chat, where the passive approach is just a small part of what we have written down here. So there is ample access, a wide world to be explored, and we have to think of ways in which we can use this AI efficiently, and not in this repetitive fashion. So this is the big challenge of our reflection. So once we've gone over this theoretical part that explains to you the difference between one model and the other, we're going to show you how it's been, this journey of the Horus project, how it has been. It's a journey that we have used and traveled in at the state court system of Tocantins, especially in Dr. Marco's department office, actually, which is the experimentation of a theoretical model that has proven itself very efficient for use by the judicial branch. Ever since its conception, this project has had some keys, some points that are not negotiable for us in the law profession. These negotiable parts have been brought to the modeling of the system. When we talk about points that are not negotiable and unsurmountable, the question of human rights and all of the ripple effects on fundamental rights that are enshrined in the Constitution, and most of the lawsuit guarantees, they are enshrined in the fifth chapter 5 of the Constitution. It's something we cannot tamper with. Technology allows us to have any kind of mitigation of fundamental rights. Yes, it does. Technology does not have ethics. It's us human beings that have ethics, and we have to use that ethics to use technology and apply ethics to technology. To authoritarian countries, like we have said, may use artificial intelligence, generative AI, and the judiciary for intense social control and frontal violations of human rights. And that's what our Constitution is. That what it says we should do? No. So we must not conceive, even conceive of an idea of artificial intelligence model that could actually jeopardize individual fundamental rights. So it generates support and optimization of the legal branch of government. It's support. We're not replacing judges or civil servants. We're supporting them. And then what we're doing right now at this point, as we speak, is to develop maturity of artificial intelligence. We've done actively at the State Court of Tocantins and other courthouses in Brazil to create innovative solutions in artificial intelligence on topics such as ethics, security, explainability, human validation, and traceability. In addition to validation of artificial intelligence, they've been conceived at every step of the modeling of this generative artificial intelligence called Sarah, which you will get to know momentarily. And we started this modeling here in Tocantins. So the partners in this project and the School of Magistrates here in Tocantins, the courthouse, COPEBEN, our group of research at the University of São Paulo, Smart Cities BR, our unit at the University of São Paulo itself, and the startup are here. They're all here together in this project. This is Professor Luciano. This is the appellate judge was talking about it before. It's the picture of the signing of the agreement a partnership agreement of cooperation. Our research group at the University of São Paulo, together with Tocantins, the courthouse of Tocantins, in this room, an iconic painting by Pedro Américo at the museum, at the Ipiranga Museum in São Paulo. It's a very important moment, and the date was very important too, August 2023, because it was yesterday, actually. So it's been over a year, slightly over a year, and you will see how many things have happened in this period. And it's one more important point, this change in this paradigm shift within the perspective of time, the development of the time of development of solutions and its adaptation. We will notice that we have a challenge ahead of us and a huge opportunity with this new technology. As for time, one more remark I'd like to share with you. When you ask us to change one line in the system, in the judicial branch, be it judges or civil servants, could you have a button there which will analyze and which will fish out the information? After 2 or 3 years, you have the button right there. You have 7 more buttons in line, but you didn't receive your button. That's what, is that because IT people are lazy and ineffective? They want to stamp out your indicators and just do away with your department? Not really. The computational model, pre-generative computational model, remember that we were talking about standardization, and it will get in line, a line of priorities in the area of IT, and there are so many things that you have to do at the courthouse. Your little button is one more in line. There is no possibility for you to request that the system will deliver more than they're able to deliver, actually, that the system can deliver. And today, there is technology, disruptive technology, that's able to assess, analyze, compare, and deliver solutions in natural language with easy access, and we didn't have that beforehand. So today you have the solution can come easier, more easily and faster, even though it's connected to older systems. Yes, as for time, this remark, the ability that this new technology has to ensure agility, speed, and secondly, time is not on our side, on the side of those who are thinking, well, I'm talking about managers now. The judges are the managers of their departments. The appellate judge is the manager of the tribunal. Ministers are managers of their offices. The president minister is the manager of the tribunal. There is no time for managers that vacillate. There's no longer time for managers, for scared managers, for managers who hesitate. Oh, let me put in 3 more tribunals. We'll see how it is. I'll bring them in if I have the chance, so we'll see how it works. When something works out in a certain place, for example, the largest tribunal in Brazil, in São Paulo, we keep hearing the sentence, when São Paulo does, the rest of Brazil will do it. When São Paulo does it, the rest of Brazil will follow suit, because São Paulo is the largest one. I have news for you, though. This tribunal right here, from a small state, larger than mine, I'm from Sergipe, but it's a small state nonetheless, compared to the state where I live, which is São Paulo. The state right here has innovated when it had the courage at the School of Magistrates. As soon as the technology was out, they went all the way to the University of São Paulo. They sought out 2 professors that were there, and they asked them, what is this? So tell me what it's all about, and let's run tests on this new technology. And that is something priceless. At a time in which those who keep thinking and daydreaming and waiting, oh no, it's not safe, test it. Look, research. And this tribunal did exactly that. You have to be very proud of the courthouse of your state, which is an innovative tribunal opened to looking, testing, and analyzing things. That's the attitude of innovation. You accept your mistakes, you own them, and the possibility of things not going the way they should, but you do not accept the possibility of not testing things. Time is not on the side of those managers who don't understand the transformation that is going through. These doubts that you have are fair. Fair enough, and that's why we keep saying that from the very beginning we put them. It's a negotiable principle. It's not negotiable. Something strong by design. Some of these issues, transparency is one of them. We don't want to have a black box in which people only look at outcomes. They don't know what happens. So here, for example, we're looking for transparency, modeling with several actors, presentation of documents, and what was found, and what was the rationale, and what's the reasoning behind it. The rule, a complex rule that was checked. What website did you access, and what's the jurisprudence that you used, so that people will know what happened. And once they are able to know what happened, they'll be able to assess whether that is right, wrong, or whether it's within an acceptable assessment. That is, the decision is human. The decision is not an algorithm. They'll support it. They'll show you everything. And that is a definition. The tool has to have that definition. That's what we're bringing to you. Look what we have found. We suggest this route because we have found this, period. There is a high demand by our jurists concerning the use of generative artificial intelligence as for explainability, so that the control will remain in the hands of judges and not in the hands of the algorithm. Okay? In the case of generative AIs today, for reasons of breakthroughs in the technique, we're oscillating between two large issues, then we have to choose between them. Either you choose a model that is mathematically explainable, but with limited delivery ability and limited quality, or you will choose a model that mathematically cannot be completely explainable, but it's got a delivery capacity in a natural language that is quite considerable and acceptable. So the explainability, and that's we've had the chance to defend it before the International Justice Commission. It cannot be a requirement to put to the algorithm, but it's a series of steps that AI traveled in order to get to that suggestion for humans. Exactly. It doesn't solve it. For example, if you know why point 4 was used for that document and so on and so forth. But what people want to know, and how was it analyzed? What was analyzed within that document? These suggestions presented here are based on what exactly? And humans, could they choose, or this algorithm did everything in hurried fashion quickly? And that's the explanation we're looking for. Another fear that we have is for concerns human rights. AI, is it going mad, or is it making mistakes? We've been using the expression AI went berserk when they gave us an answer we didn't like. It went berserk. I like it. If I like the decision, it's fine. But if I don't like it, AI went berserk. In the area of computational science and articles and texts of review texts, we've been talking about several concepts of hallucination, but a reasonable concept says that the response of artificial intelligence escaped the bounds of acceptable rationality. So I'll ask you, what's the name of the parties to this lawsuit? What are the articles that the parties asked for? And what's the root cause of this request? And they'll give me the recipe to a cake, for example. It provides a completely different response. It happened in I've used it twice, and I like it when they go berserk because I can tell it's wrong. And what do? I'll start again the processing. And it's not exactly when they did something wrong, but when within the range of probability, it gives me something that looks so certain, so legitimate. And when I look at it, it does not have the legal foundation, but it does have the probabilistic foundation.
We're speaking of an algorithm. By speaking about an algorithm, how do we bring probability to us? Well, we'll improve the database where the algorithm is trained on. Try building a database, improving the basis on which we're trained, and using better techniques for this architecture where we can check AI with AI, and you can check human with human validations. We make mistakes.
Nós erramos. A IA simula
We
o
make
que
mistakes.
somos.
AI
Mas
simulates what we
ela
are.
é treinada
That's
na nossa
generative.
base de
It's
dados.
trained on
Nós
our
produzimos
database that we've
erros.
produced that
Ela
have
identifica
mistakes, that
padrões,
contain
e ela simplesmente
mistakes.
nos
It
devolve.
identifies standards or patterns, and they
Então, vai
return to
haver
us
erro no
these
processamento,
patterns.
eventualmente,
Will there
de
be a
uma IA?
mistake
Vai, como
in
haveria erro
the
na
processing
nossa
from an
atuação
AI?
do dia a dia.
Yes, as
O
it
que
would,
podemos fazer
as
é
we would also
treiná-los
make
de
mistakes
tal
on their
forma,
day-to-day
em
work.
ambiente
But what we
fechado,
can do
com a
is we
base
can
de
train
dados feitos com
it
curadoria, para que essa
we can
probabilidade
train
venha
it
até
on a
nós
closed
ao final e ao
database,
cabo. Nunca
closed
é
database
dispensável
with the
a
curated
curadoria
database,
humana para
and we
uso
must
de
always
dados
have
generativa
human
no poder
curatorship
judiciário.
to use generative AI in the judicial branch. And how about bias? We can have biases. Sure. Here we have a quick expression that the bias is a tendency or trend determined by external forces, or in the case of AI, data. So what's inside that data? Well, if we had a social behavior where in the past it was accepted, that would be represented in the information or in the data. Let me ask them a question, listen. Would we find over there in an older jurisprudence of the tribunal, would we find a decision from the appellate court judges rendering innocent a defender because the woman was using suggestive clothing? Is there maybe a decision such as this one in the judiciary? Yes, I'm sure there is. Is it acceptable today? No. So the fact that it is represented in the data does not mean that we will be accepting it. AI learns, and when it learns, we tell it, this has happened, this is no longer acceptable. So do not reproduce this characteristic. It must be, the AI must see a good sentence and a no longer applicable sentence. It must have, you must show it all of an initial petition that has all of the right data, and it also must be shown an initial petition that no one today can understand what was in that initial petition. So, is there some kind of data within this data complex of this tribunal that is of good quality? And is there some data that is of bad quality? Well, the AI needs to be trained to learn what the difference is between good quality and bad quality. It must be trained to know what is current jurisprudence and what is old, outdated jurisprudence that existed but should not be reproduced any longer. That's part of the training. And we often have the issue of a dynamic society. It evolves. With today's behavior, perhaps tomorrow we'll find out that today's behavior is no longer acceptable. It must be evolved. We'll find out what the newer biases are. And we have also desirable bias, that when you have a court case of someone who is terminally ill, well, that person is leapfrogged ahead. That person will have a better priority, more priority. Some of the biases are good. Bias per se is not a problem. You can have good biases, and we can treat the bad biases using AI. And there's some that we don't know. When we know, we'll treat them. And the question that I posed at the beginning, the judiciary coexists with the process, with error, with fraud, and it uses mechanisms to mitigate this. It will be no different with AI. It will be using mechanisms to mitigate and control this. So what are the results up to the moment of the ORIS project? Well, we've published 2 books, which are international bestsellers. They were published in Portuguese and English, and at the day of the publication, they became Amazon bestsellers. One of them you just won out. You just won. You did. You've won cyber resilience. Only for those who are here present. If you're watching this online, you can head to the website of the Amazon. The Federal Senate had a manifestation on the AI project in Brazil. In the Supreme Court, one of the companies showed a possible solution, and that is that startup that is with us here. And we built Sarah, an adaptive system of analysis of appeals and ordinary actions. What is SARA? Analysis, what are the differentials for the judiciary? A large-scale analysis of complex proceedings, complete automation of the flow, ability to customize for the magistrates, inclusion, security, traceability, and audit. So SARA builds audios for those who are hearing or visually impaired. Has opportunities from 6 p.m. to 6 a.m. AI will do the translation and you'll work for the end of the day. So it also provides security, traceability, and audits, and velocity of creation. So now we'll be showing you a little of what Sarah is capable of and does. Appellate court judge Marco had asked me, are you guys going to be showing Sarah? Yes, we will. I'll say the following here. AI is excellent, but natural intelligence will also have to learn when we put, well, we'll have to learn how to cook. So this is work by 2 hands. Perhaps the third hand will be available only on standby. Wonderful. So let's get to know Sarah. This is an interface. It's a web interface. There's an open general use option, but let's use the closed judiciary use web option. This is natural intelligence. This is as good as Alexa. Scroll downwards, it works. So all of these tools were developed now. Stop right there. Can you see that the purple over there? Recently, there was a National Justice Council decision that determined the standardization of all of the amendments. This resolution came out one day. 2 days later, Sarah was already processing information and creating these amendments.
Copiar documentos.
Vamos lá, escolhe fraude bancária.
Qualquer
So choose any fraud. It takes the process notes or observations, analyzes everything, and simultaneously it is analyzing each one of these documents, simultaneously classifying each one of the documents, identifying what is the type of document, what is it, and based on this classification, it looks for important information that would help in the analysis. So it's classifying, and at the same time, it is preparing the decision or the menu. You can type information here. You can upload. Over here, we've uploaded 18 articles. Some analysis have hundreds of documents. We've had hundreds of files analyzed. So it's here analyzing each one of the documents. And as it is being classified, they start showing up in the categories. Please click in decision, lower. And here it shows up. It has a summary, which is the decision and what is most important. So here we have documents, we have payment slips. Each one here has a classification, and at the side you have an inclusion. We talked about inclusion, so you can have an automatic audio file issued. You can also have sign language. A presentation for those who need it. You can download in Word format. Sign language, a very well prepared professional here who is translating in sign language to be able to have thousands and thousands of PDFs translated into sign language would be inhumane. So AI is very interesting because she will be working with her potential to help her in this support. She will be a partner. The idea is that the inclusion may be offered. This should be inclusive to all people. So here we have the menu created with the 4 areas that have been established: exams, discussion, reasons. This is a menu in National Justice Council format. This was there was an appellate judge that did not want to use it, and we asked why. Well, this structure subdivided into 4. It's if you didn't like it, so if you didn't like the national, if you didn't like this standardized in National Justice Council format, then it's tough. I mean, we've done it in the standard. So here we have Superior Justice Court. Here we have appeals that we're building. These are formats of documents. Please scroll downwards. Sad. Over here on top, we have the Supreme Court just below. Just above data extraction. So let's do an analysis here. The first one, okay. Over here, it is assessing all of the documents, and this is a tool to analyze the admissibility of certain information, admissibility of certain appeal instruments. This is the analysis that it is doing right now. And it emulates the manner where the president's sector of this tribunal, it emulates the way this presidency in this state court follows. It's this analysis. Other tribunals may have other analyses. So why are there differences between state courts? Well, the normative is the same. Normative part is the same in all of the state courts, but the flow chart of internal analysis and the departments that do the analysis and the internal stages of each analysis are different for each state court, for different state courts. So this is customized to the way this state court works. And how did we build this? This first stage, how do we build it? We did this in the classroom with workshops involving the participation of many different actors, servants, magistrates, professors, all of them working with these flow diagrams to build something that is safe, transparent, and with the possibilities, the perspective of avoiding sensitive data leaks, and within the perspective of ethical use, regulation, bias control, and we've been very cautious about all of this. So this hasn't yet been used in the jurisdiction. We've had this used only in the academic environment, not yet in real life use. In terms of process, we have many jurists. Over here, there's a step-by-step which the law imposes when we analyze appeals, but it's a step-by-step way that is connected to the tribunal. So the first thing is we needed to analyze if it's timely, if there's timeliness. As we're not doing this in the environment of this system. Now, if other criteria is if this should be free to the citizen or not. Well, we'll find out what the payment slip is. It finds the payment slip, and then it finds out what the fiscal document is, and it compares. It compares the payment slip, and you can see, scroll down,
E aqui é a guia de pagamento.
And that's
O
the
que ela
payment
faz?
slip, the
Checa se o
receipt.
valor bate,
So it checks to
se o nome
see
da
if the
parte
amounts
bate,
are
se o
in
número do
agreed,
processo
if the
bate,
parties
checa
are in
todos os
agreement,
dados. O que o
if the
humano faria
identities
na
are in
checagem,
agreement.
ela faz.
Whatever the human does to
Professora, se a
verify the
guia for
payments,
falsificada,
the computer does.
se a
So the
guia for
AI does so.
falsificada,
Well,
você,
if the
você
if the
saberia
payment
que foi
slip is
falsificada?
falsified, as a human, would you know that it
Provavelmente
is?
não.
Probably
A IA
not.
também não
So
vai saber.
AI will
E
not
como é que a
know.
gente tem a segurança
So
disso?
how
Conexão
can we
do
be
sistema
safe?
do
Well, we
Poder
can
Judiciário
connect
com o
the
sistema
judiciary
brasileiro de
system
pagamentos,
with
isso deve
Brazil's
acontecer, porque não faz
national
sentido o
payment
judiciário ter de
system.
checar a guia de pagamento. É uma etapa
So this is
não
a
justificada. Repetitividade.
so
Vai se
repetitivity
analisar se o
is this
recurso é ou não
it will
uma
be
demanda
analyzing
repetitiva.
if this
Pra
is
avaliar
a
isso,
repetitive
ele vai buscar,
appeal
né,
to,
os
to
chamados
evaluate
temas dos
it will look
tribunais
at the different
superiores,
subject matters
se há
of
ou
upper
não uma
courts to find
conexão
out
desse tipo
if
de
there's a
julgamento,
connection
desse
with
tipo de
this
ação
judgment,
com
with this
tema
kind
já
of judgment, with
estabelecido
perhaps
nos
another
tribunais
one
superiores,
where there
ou
may be
seja,
precedent
ela
other
acessa
previous
a
decisions
internet para
of upper
checar a
courts. So
jurisprudência,
it will access the
tema
internet
e
to
súmula.
check the
Coisa que o
jurisprudence, the
modelo
subject,
da IA
and
generativa
previous
passiva
decisions
não é
that
capaz
which
de
a
fazer,
passive
né? O modelo do
generative
chat
AI
não
would not be
conecta a
capable to do.
internet
A
para
ChatGPT is not
buscar
able to
essa,
do that. A chat AI is not
informação.
able to
Se há
obtain
ou
this
não
information.
precedente obrigatório,
Is there, for
da
example,
mesma
a
forma,
binding
ela vai
precedent?
até
Over
a
here,
internet e busca.
again, it seeks out the internet
Clica no Ver
and,
Mais.
and checks this.
Aqui, ó, ela
Over
foi
here,
na internet e buscou.
it's gone to the internet and found out that
J e do
at the
STF,
Superior Court as well as
e ela
the Supreme
busca
Court,
as emendas
and
dos
it seeks
processos
out what
similares
are the
para apoiar o
process
magistrado.
text to
Imaginem que a gente
support the
conversou
magistrate
com
or the
alguns servidores da
manual.
área, a gente
We've
perguntou
talked
quanto
to some
tempo
public
vocês demoram
servants
para fazer uma
and we
análise
asked them, how long
dessa?
does it take to do an
Olha,
analysis
professora,
such as
se
this
for um
one?
processo muito
And they've responded
recorrente
to
e
us,
simples,
if it's a
a
simple
gente
process,
demora aí
it takes us about
dia,
1 day.
né? Pode chegar de 2 horas a
Maybe
dia se for um processo
anything from 2
recorrente.
hours to 1
E eu
day.
falei,
If
e um
it's a
processo que
recurring
não é tão
process.
recorrente?
But
Pode
how
chegar
about an
uma
unusual
semana de
process? Well,
análise.
it could take up
Em
to
quantos
1 week to
segundos ela
analyze.
fez a
And how many
análise?
seconds
Não chegou
did
nem a
AI do
minuto.
this? It was under
Será que
1
isso
minute.
apoia o Poder Judiciário
Does this
brasileiro a ser
support
mais célere?
Brazil's
Sem dúvida,
justice
apoia.
system in being more agile? Yes. That's a general repercussion case.
Isso é
That's
importante.
red.
Ela
This
não
is important.
gera
It does
conteúdo
not actually
probabilístico não
create
desejado. No chat
AI does not create
o que que acontece?
undesired
A IA
probabilistic
generativa, ela
content.
gera dentro
In
de uma
ChatGPT,
probabilidade.
it creates
Então é aquela
a
notícia que saiu
probabilistic
no jornal. Juiz
content.
usa chat GPT e se dá
There
mal.
was a
Ele
news
inventa uma
item where the
jurisprudência que não
judge
viu essa
used
notícia no ano passado,
ChatGPT
e o
to
pobre
base his
juiz
own
está lá sendo
decision.
julgado no CNJ. Eu tô com dó.
He judged
Por quê?
this and he
Porque é um
used
modelo aberto e
AI.
a função
But
dele
that
é
is an
gerar. Quando você
open
treina no
model.
modelo
ChatGPT is an
fechado,
open
lembra que eu falei para
AI
vocês que
model.
você traz a
When you train on a
probabilidade
closed
para
system,
E ao trazer a
probability comes close to
probabilidade
you,
para
and by
perto,
doing
você
this,
aumenta a segurança
you
jurídica,
increase
mas isso só não
legal
resolve
security, but
treinar
by
no modelo
itself,
fechado.
it's not enough
Dessa
to train in a
arquitetura,
closed
desse
model. In
modelo
this
que nós
architecture of this model
criamos,
that we've
ela
created,
não gera se
it
ela
does
não
not
encontrou a
create
informação assertiva.
information
Ela
if it did
simplesmente
not
avisa,
find the correct
etapa
information.
inválida.
It merely warns you that this step is invalid. Could you click and generate the
E quem
minutes?
deu essa minuta pra gente?
Who provided us with this minutes? Aria. And it's not a minutes where the place, it's not a template. It will actually verify the documents and add the content in accordance with the document. A frequent question that people have is about the safety or security. Is this going to leak or not? This issue we can subdivide into two different areas. One is regarding the use of the AI. Here we have the model. Here we have the minutes in the way the tribunal in the same template that the tribunal uses, ready for use. And back to my explanation, when I am using an open chat, it's written there that you should not send anything that is confidential because it could be used in training the open AI model. But when we use our own professional solution, under contract terms, this information is not used for training the model. And the data is controlled by a level of access. They will be accessing they'll be accessing information. Only those who have access will be accessing. just as in any other password system, each one has different levels of access. And in the perspective of the system, we all use, it's state-of-the-art in terms of information security, by the way, which is why we have 2 books, one in generative AI, active generative AI, and one on cyber resilience, because the areas work together.
We have to worry about data security, the risk of leakages. There are approaches that are being used in the safest systems in the world, and that's a contractual clause. There is a recurrent fear that we've heard, even at the events we've done at the judicial branch, how the country's judiciary will fall prey to the big techs. Won't they use our data? Every single court in Brazil, they contract cloud services. You're already clients of a big tech. Your lawsuits are in the cloud, and some courthouses. Others have physical data centers and the cloud. Others have only the cloud. So far, have you wondered about not using internet and the cloud internet, because eventually there might be invasions by big tech CEOs to get your data? It's in the contract. It's a clause in the contract. Artificial intelligence is the same thing. Security clauses not to use data from a judiciary to feed your big model. That's a clause enshrined in the contract. Unless we want to be a paperwork judiciary, unless we want to go back to paperwork, our security risks will be other. Different. For example, a defendant will set the courthouse on fire, and the lawyer, for example, will eat up the promissory notes. And that's in the books. It used to happen. What's the kind of risk that we have today in terms of security in the digital proceedings when the government and the state starts moves to the digital world? They'll be running other security risks. What's the pattern that they'll use for protection? Contract clauses and internationally accepted security standards. Brazil is among the 10 countries in the world with the highest number of digital public services. Brazil is a powerhouse in digital government. The Brazilian judiciary, until it was the first #1 in the Americas, surpassing Canada and the United States. As for digital government, the Brazil's judiciary is almost 100% digitalized. Our lawsuits are in the digital world. When we become a country with high intensity of public service delivery and jurisdictional services that are digital, we also become the target for criminal crimes. And how do I contain them? Using international security standards. You already do that when you hire cloud services for your lawsuits. With generative AI, nothing will change when it comes to that particular issue. Therefore, we think, given this broad view of generative artificial intelligence and what we can do within SMAT in academic terms by way of research and testing, you can envision what this judiciary power of a branch of government in the 21st century. It is very different from the judiciary branch that we've had so far. It's a judiciary branch that's all the more agile, and it's incumbent upon all of us in the legal domain not to allow human rights, ethical limits, and security limits, and transparency limits, and legal security limits, and data security limits. We have to make sure these limits will never be trespassed. Hence the importance of regulation with moderation, without excesses, not to inhibit innovation. In this case, European Union regulation was too harsh, excessively harsh, which renders it difficult to innovate. And the American model is open open, very open, I would say, and eventually it makes it hard to protect fundamental rights. What's the middle ground? I don't know. Nobody knows the answer. It's up to us to build collectively in the Parliament of Brazil and together with the National Council of Justice, and that's what we're doing at the University of São Paulo. We're trying to provide support from the university to these large discussion fora on the use of artificial intelligence. Again, thank you for coming, and thank you for listening to us and this presentation. The institutional project of the University of São Paulo has met the courthouse of Tocantins and the COPEDEM. Thank you so much. Thank you. Great lecture, Professor Luciano Araújo, and Dr. Lauro, and Dr. Luciano Vieira Araújo for your brilliant presentation, showing the benefits of active secure artificial intelligence and the benefits of the use of this tool for the judiciary. It's very important to wait around. We've had recently, when it comes to big techs, there was a very well-known big tech, and they discussed in the Supreme Court a case of national sovereignty. It's something very important to take into account because these are the richest and most powerful companies in the world at the international level, and to think that the digital transformation on a global scale has broken through physical borders. There are interest groups, vested interest groups, in this new global order that transcend typical interests of the national state built by positivism, and that led to a concept of that's very essential to the organization of the United States, for example, and the large family of nations that ensured the evolution of Western societies, Western science and Western democracy. That's today it's been jeopardized by the big techs. It's been called into question and at risk because of big techs. We have to have contracts with these companies for the proper use of technology, and so that democracy won't be ruined, because an authoritarian artificial intelligence, an autocratic model, would be something extremely undesirable. Imagine if all the countries in the world, all the international community were to be dependent on an authoritarian artificial intelligence that would suppress the exercise of the activities of the legislative branch or the judicial branch, and even restrict these acts by the executive branch of government. It's something very complicated, very worrisome. These are the issues that I'd like to draw your attention to. And Professor Lauro Ishikawa from FADISP will be addressing some of these issues. He's one of the most brilliant minds at that university, and has been very active in Brazil. And FADIC has a large campus in Goiânia. I had the chance to pay a visit to the São Paulo campus as well. And we have set out the beginning of joint activities through a partnership agreement signed by us in a cooperation to undertake many joint activities. I would like to invite Professor Lauro to give us a critical reflection from the point of view of academia, external to the judiciary branch, and how to use artificial intelligence and the legal system and the prospects of the regulation and how we can use that safely so we may deliver and promote the dignity of human beings. Professor Lauro, please. Lauro Ishikawa. Thank you very much. Appellate Judge Marcos Villas-Boas. I'm very honored to ascend to this podium after two brilliant presentations, such a magnificent joint presentation, so inspiring. We're comfortable. Myself as a lawyer, I'm comfortable knowing that we are at the hands of people with so much expertise and committed to ethics. I have learned a great deal today. Thank you very much. And I'm very happy, even Appellate Judge Marcos Villas-Boas, to know about the fact that you're that you're going to be holding your position in the next biennium, and that for us at the FADISP University in São Paulo and the UniAlpha in Goiânia, we're very honored to participate jointly with you and to be here together with you. And it's such a privileged location at the school that I've had the chance to say that this morning. And it's a school, one of the most notable schools of magistrates in Brazil and the judiciary branch. I'm absolutely sure that the citizens of Tocantins have gained in scale through the work that you do at ESMAT. I would like to acknowledge and extend a warm salute to my panelists and all of you, ladies and gentlemen, in the audience. Really, this is a great honor for me to be here on the eve of the anniversary of Tocantins as a state. On the eve of the anniversary of the federal constitution on Friday afternoon, as Professor Anna has said, I should congratulate each and every one of you for sticking around so late, and for whether presently or in hybrid fashion in the virtual world. It's a pleasure to have you all here with us. It's a big challenge to actually talk about this topic after two experts have talked about it. They're such distinguished experts on the topic of generative and artificial intelligence. 2 years ago, we didn't have any of that 2 years ago. When we prepare papers and lectures, we do research. For example, we look for generative artificial intelligence. It started appearing starting towards the end of 2022. We're talking about something that's really very new, very novel, and the novel, we were talking about it this morning, the novel takes a while for the novel to be, what's novel to be assimilated and read. I will start my talk, as always, with a theoretical framework. I'm very tranquil being right next to Professor Ramos Tavares, the Minister of the TSE, and the full professor at USP, and our coordinator at the PhD course at FADISP, at this new work that was launched in July at an event that we had together at the Siena University, which is New Matrix, the reprogrammed law, civilization, and the platformized civilization. In the words of Professor Ramos Tavares, disruption has already taken place. We have broken a paradigm. We have crossed the border of the new, and the new is right here. What's novel is right here. After this brilliant presentation, I will go back to theory. I will remain in my own square of academic theories, because in fact, we're here faced with something that's and under huge transformation, undergoing big transformations. Perhaps next year everything will be will have been clarified. There's still a project in construction, but we do have a great deal to celebrate already. When we listen to the president of the Supreme Court saying that artificial intelligence is the survival, a very survival of the judiciary branch, we have a starting point that we don't need to convince anyone, no one at all, except those who are really hesitant to absorb the new. This reluctance took place recently. We have electronic lawsuits. We've had electronic lawsuits for over slightly 10 years. Minister Barroso, Professor Ana Clara said that 100% of the lawsuits have been digitalized and electronic. In fact, when we turn our eyes to 2013, we had an absolutely different reality of a lawsuit, a paper lawsuit. I don't miss, as a lawyer, I don't miss paperwork at all. I remember running paperwork by fax, and Professor Anna and Professor Luciano were too young to know what I'm talking about. Appellate judge heard of those times, but that was my age. what you people would send out faxes of huge lawsuits. I really don't miss that era. Do you, Apple Judge Villas-Boas? All of a sudden, we had this huge technological revolution. Back then, we had good relationships with Spain and Italy, and our Spanish colleagues were saying the older lawyers are hesitant about advocating anymore because they refuse to learn what's new. And the new breakthroughs were simply how to use electronic lawsuits. It's apart from a constitutional premise. Professor Ramos Tavares draws our attention to the constitutionality of this theme, the constitutionality including this activity, even though it be it public or private, especially in the private realm, because he deals with that in his own work, The New Matrix. He says that the creation and use of technology for illicit economic ends find themselves within a space of protection and constitutional framework and delimitation. Why does he make that statement? Because he says any Ramos Tavares, any law that discourages or even vetoes technology will be deemed unconstitutional. And if we look for the word technological in the federal constitution, we will see that there's over a dozen provisions within our Magna Carta. So there is a constitutional premise. The use of technology in the internal market allows the promotion of one of the finalities of the Federal Constitution of '88, which is development. If we are to look at, for example, Article 7 of the Federal Constitution, it talks about the protection against automation, protection of workers against automation. This against is not written, but that's the reading that we used to do back then. We would still be in the paperwork era. We would still be stuck in the age of research, paperwork research on how to get to Palmas, for example. We wouldn't have a Waze or a GPS or any of that, or anywhere in Brazil. So state actions under these constitutional terms should stimulate innovation and technology in the private domain, especially when it's relevant to the national development and regional development as well. And Article 219 says it very clearly. The state shall stimulate the formation and strengthening of innovation at the companies. Obviously, that we're talking here about innovation in the judicial branch and in the field of public administration, which obviously is very clearly explained, and which was stated clearly by our dear professors who spoke before me. Obviously, there has been a great deal of criticism pertaining to benefits that are exalted, but on the other side, there has been a great deal of criticism. What's new again? The novelties take a while to be assimilated, and here we have these paradigms, different paradigms for artificial intelligence. Today in the generative artificial intelligence, so much, even more so. These authors that got the Turing Prize in 2018, they draw our attention to the question of paradigm, the paradigm of logical inspiration, that looks at sequential reasoning as the essence of intelligence. And it aims at implementing reasoning in computers using rules of projected inference, projected by hand, that operate in symbolic expressions designed by hand and formalize knowledge. The paradigm inspired in the brain looks at representations of learning based on data such as the essence of intelligence, and aims at implementing learning through the manual design or involving rules to modify the forces of connection in simulated networks of artificial brain cells.
The OECD had called attention to these principles, these recommendations on AI. Professor Ana Carla has already talked about most of them. But quickly, these 5 principles here that are based on values for the administration that is responsible for an AI that is trustworthy, including growth, sustainable growth, sustainable development, well-being, values that are centered on a human being and justice, transparency and explainability, robustness, safety and protection, and accounting and accountability. This author, South Korean, he has a criticism that seems to be very appropriate when we work in when we think about the market, and he says that some few very large companies pretty much have the records of just about everything. One sole company has data on 300 million Americans, which means that they know more about Americans than the FBI itself. And he says, and here we may have a bit of the bias that Professor Lucena mentioned at Axiom, this company that he cites. People are subdivided into 70 categories, and they are offered up, and they're offered up as if they were merchandise. For each need, there's something to buy. So they gave, Darren from MIT says that there's an excess of data. Today, currently, we have an excess of data, and this could compromise the market itself, because not only does this go into the intimacy and privacy sphere, which he cites in a research where he did some survey, and many of the surveyed individuals are not really concerned with intimacy and confidentiality when that person is under something that could be useful for that person. When I downloaded, I've never worried when I downloaded Waze, when I downloaded my banking information, or my games for my children. Whenever I downloaded something, I just clicked. That's kind of like a click contract. You click and you sign the contract. I don't know what's behind this, but I do hope that Professor Ana Carla had given us an answer. That's a contract clause. No one's going to break it, but we are exposed. That is a fact. So big data, that means that a part of the major problem that we're facing right now, this became an important mnemonic or abbreviation. What is GAFAM? The 5 major big techs, and its market value. You have Google, Alphabet, Apple, Amazon, Meta, and Microsoft. They're at the end of 2022. Now we're speaking right at the beginning of generative AI. At the end of 2022, they were cumulatively worth $6.7 trillion, $6.17 trillion. And in February of 2023, they were then worth $7.28 trillion, which represents a growth of $1.11 trillion. To quickly compare this, the size of this growth, this means that the growth, the cumulative growth of these 5 companies is more than the total market cap of Brazil's stock exchange. Goldman Sachs has a survey out that says that a study that says that there's an increase in 10% of world GDP. World GDP will be 10% of the growth worldwide will be on generative AI next year. This has officials scrutinizing this because we are we're facing companies that know everything about us and we know very little about them. This report here, this report from the Federal Trade Commission, a look behind the headlines, it examines the data practices of data streaming and video. In 2020, the FTC issued orders for these 9 companies, and they had to start filling out forms. And what are the conclusions that were published just now? In September of this same year, right now, this report is titled A Look Behind the Screens. One thing is that the status quo is unacceptable. Without significant action, the commercial vigilance ecosystem will just worsen. Self-regulation is not a proposal. That's second issue. That which would be a gray zone to promote growth and discernment, this that we are witnessing today, which would be exactly the absence of responsibility or accountability of these companies behind these platforms so that they could develop themselves. We're speaking about a little more than 10 years. About 10 years ago, if this discussion existed, it was almost like a futuristic viewpoint on the future without much predictability regarding what these companies about 10, 11 years ago did not have the same size they have today. And to fix the system, we have to fix the incentives because without the significant protections, the companies are incentivized to develop ever more invasive methods. And once again, Professor André Tavares provides us a brilliant result on its academic research. And this work is called New Matrix. The professor promotes that the new technologies will be built on networks because these are digital keys that are disruptive. Disruptor has occurred. It's possible to analyze the power that these technologies exert on society and political institutions and what structural impact they have in jurisprudence and the law. We've spoken at length this morning about the structural issues in this context of the state of unconstitutional issues. And the law professionals continue to search and to capture digital phenomenon with instruments and legal categories that were, in great measure, thought and created in centuries 19th and 20th, incapable in practice of offering satisfactory responses to current problems. So what we have now is I'd say that we're witnessing the current judicial system is watching this in backward. So listening to Professor Ana Carla, we talked about this constitution in network where everything is connected to it, or build up in the network format. The only instrument that is able to offer this new presence adapted is the new jurisprudence. Last week we had a rich debate on generative AI, and which is why I again affirm that ISMAT is in the vanguard, in lockstep with what is most modern in this country. Last week we had a public hearing at the National Justice Council with Mr. Barroso. He affirms that generative AI is an issue of survival. The use of AI is an issue of survival. We have a judicial we have the legal courts with over 80 million processes that are pending, court cases that are pending. So it is necessary. Regarding, we've had a protocol of this first survey report, and this survey is led by a law professor at USP, and he says that regarding application for the tribunals, that generative AI, which create text, which the main ethical concerns regarding its use by magistrate and servants are connected. This is not a qualitative or it's not yet even a statistic. Why? Because it was voluntarily taken, and it only dealt with those who actually answered. It's fully voluntary, but in the answers obtained, there was a first impression. Many magistrates and servants are already using, in some manner, some kind of AI when they do their work. So what are these ethical concerns? First of all, the risk of having an automation bias and the lack of transparency with the need of having governance measures of training and dissemination to clear up the adequate use as well as inadequate use of the tool of organization to review the created contents and transparency. We hear this word often enough in this report, transparency. Many among parties on its use in the elaboration of tasks that are proper to the functional activity. So here we have a first concern put forth by this committee, and we had this discussion last week at the National Justice Council. So regarding institutional measures whose adoption is recommended by literature and international experience we must make available officially these tools to servers and magistrates, and as a means of stimulating the transparency and mitigating doubts as to the proper and legitimate use. The training of the servants so that we have an adequate use as well as responsible use. And I've heard here that the workshop where they had this training involved magistrates and servants in its own formulation of the project. And 3, the evaluation of suppliers of AI, of generative AI, to be used by the tribunals in terms of its policies and technical tools to provide quality in the results, to filter content that could be discriminatory, which is the negative bias or the discriminative bias cited by Professor Luciano. And there's a natural trend of the individual to follow a certain standard or pattern, and that is a serious problem, because when we follow patterns, we sometimes set aside that which does not follow the pattern, and that is a problem that has been debated at length on the automation bias when AI makes a decision or reaches a decision. And there are those who say, perhaps allow the machine itself to create this AI, the machine itself to create the AI, because it would be exempt from this kind of discriminatory bias. But if AI is created by data supplied by individuals, then that is something that could be a Black Mirror kind of situation. If you haven't seen Black Mirror, I recommend not watching it, because it really is, it really affects us. I identified myself in some moments to the series, and then I kind of like rejected it, because really, to someone to think about some of the series episodes, it's amazing. So to filter content that could potentially be discriminatory or abusive, and to allow and to have private policies and sustainability. I have two comments or two lectures. In the public hearings, there were many speakers. Also from outside, there was an expert from UNESCO and from the UN. And I captured two lectures that I understood that could be concerns or suggestions of two lawyers in this public hearing at the National Justice Council. One is a professor and Dr. Renato Blum, and he talks about the principles that where AI should be based with, where general AI should be based on. Transparency. Okay, and here, I wouldn't say that this is something that concerns me. It is a proposal. It didn't seem like it was a proposal, but this is the experience that Dr. Renato brings to this CNJ hearing. For example, the use of a watermark. When, for example, generative AI reaches that decision, for example, that watermark could create a certain fear in individuals when they access that document that has a watermark where it says that general AI was utilized in that decision. That's a question mark. We have security, conformity with the legislation, compliance with the legislation, sustainability. We're actually creating a regulation, a moment where society is taking part is. Here we have also sustainability, and here there's also concern regarding the Sustainable Development Goals and the use of energy, water, and a concern that should be considered. Tests, more tests, even more tests. It does seem like we are doing this, especially here in the state court at Tocantins. Explainability, risks, and education that involves everyone's understanding of the use of generative AI. So Dr. Paulo Marcondes Brincas, he's a Bar Association federal counselor. He had a very interesting and stimulating lecture on this National Justice Council initiative, and he says, Marco and Professor Luciano, I don't have this information, but as this was held in the public hearing, he mentioned that generative AI has an extraordinarily efficiency gain. It's brutal. If you have a magistrate that uses generative AI, and if you use 50 that do not use it, and that are still in analog methods, that's a comparison. It's 1 to 50. The efficiency gains are of 50 times that of what a normal work would be without generative AI. So in a little more than 18 months of life, generative AI has placed Brazil in the same level. The regulations and the functions that are built, we've gone. Yes, we've already launched. I don't know if everyone has the same power. Professor Ana Carla says that we are among the 10 best or the 10 biggest, and this is comforting. We're not actually waiting for anyone, and we're not on someone else's bandwagon. We are building something new. We don't want to just consume something that is ready already. What are the risks and challenges? Each state court develops its own generative AI, or is it better to have a sole system under the watchful eye of the National Justice Council? This gentleman believes that each tribunal should probably create their own system of Gen AI. exactly because of the data that may be very, very specific to each state. I remember when I was giving lessons in civil rights, I used to say that there are goods, needed goods, and we had optional goods. And the examples that the civil rights books brought were air conditioners. And I asked myself, how about air conditioners in Tocantins? Is it an optional equipment, kind of like a jacuzzi, or is it something that is mandatory because it must be delivered because the air conditioners are mandatory? In Tocantins, I'm sure that it's considered a mandatory good.
That's not the reality of many states in Brazil, yet it is a very close reality to use. Just a little footnote to say that under this framework of federate states that we have with a hugely distinct dimension. I've been to the Amazon state. Until I had gone to the Amazon, I heard about it in literature and watched it on TV, and then I heard about the mode of transport. It's basically river based. It depends on how many days it will take the officials to get to a certain village in the country, in the heartland of the Amazon, 30 to 40 days. I thought it was ludicrous until I finally got to know the reality in the Amazon state. Generative artificial intelligence, as Professor Liziane said, it's going to work according to the data that's provided to it. Anyway, it's quite soothing to hear the professors say that the jurisprudence is creditworthy. It's like back then when I was a lawyer, back in the day, I had to prove where I had gotten the jurisdiction from, the jurisprudence from actually. The source had to be an official source. That is, I had to buy Alex RT. Is that it? And for forensics. Most of the youth in the audience didn't even know what I'm talking about. They have no idea. Back in the day, to work as a lawyer, I had to go to the library of the university to do research of jurisprudence. And here, since I talked about Black Mirror, I'm going to talk about reality. This is real. This is absolutely real. It's a documentary showing Bill Gates on Netflix. And it's talking about generative artificial intelligence. And I was very concerned about these two sentences. We still don't know how this knowledge is codified about generative artificial intelligence. And then he says how artificial intelligence will impact jobs, lives, and society at large. How will it impact? He doesn't know. It's just a question. I do recommend you watch this documentary because it tackles what's behind this discovery of the open artificial intelligence. Will it wipe away jobs? It creates, though, the GPT. It creates this an artificial intelligence of a generative nature. It makes it provide texts. Bill Gates says, in the beginning of the documentary, he says, I sat down with certain people and he said, look, we're discovering something very new. In this conversation, he says, if artificial intelligence solves the biology exams, you bring it to me. And then the answer was 99% right answers, and he got really excited. We're going through this moment right now of degenerative artificial intelligence. I was happy to hear Appellate Judge Vilas Boas, because here I am, just to wrap up my talk, I have here a slide. At the Bar Association, we used to listen to these endless lectures, and the speaker would say, well, I'm about to wrap up, and then he would go on for an extra 2 hours. But this is really the end of my presentation. I brought you a German professor, Stefan Kirste. He was with us at FADISP for a couple of days. It was a great experience, very enriching to all of us. but he asks a question that seems very fitting to wrap up this my participation in this panel, this great panel that we've had in this afternoon. What can a constitution reach if it includes in its text the general concept of dignity? And the answer seems to me to be very soothing as well, encouraging. He says the transformation of dignity into law and reverts foundation as a result. Dignity that follows autonomy and ethics is the foundation for freedoms and law, the liberties. And this whole discussion only makes sense if we position ourselves, and it's not about repositioning ourselves, if we keep people at the heart of everything, human beings. And the Industrial Revolution 4.0 by Klaus Schwab, he talks about this issue exactly in his following work, Stakeholders in Capitalism. When you thought of capitalism stakeholder, he had a company at the heart with all the ramifications, all the chains of relationships. Last year, 2023, he redid that design and he placed human beings at the core of this whole chain. So we are really faced with something that, if there's no understanding about it, we're going to go back to the original question by Bill Gates. I don't know. I don't know yet what artificial intelligence is capable of doing. Thank you so much for your kind attention. Thank you. I'm very thankful to Professor Lauro Ishikawa for his brilliant lecture and critical approach he did. He showed us on the use of artificial intelligence in general terms, but with obviously a usefulness in its application to the legal branch of government, judicial branch of government. That's what we should be concerned about. In fact, it was not disruptive, and the question that remains is, artificial intelligence, generative AI, has it come to help us to improve liberalism? Does it help us correct some distortions, or will it bring about other distortions? If we will recall the remarks by Amartya Sen, Nobel Prize laureate in economics, his attempts at correcting the theory by John Rawls on liberalism, in which he argued that the problem of the solution to liberalism is not in the distribution of primary goods, because people that get these primary goods, and for example, they have different abilities to use these primary goods to be able to generate good prospects in life. Amartya Sen says the following: I need to work on capacity building of these people that are not provided with capacity. They're not able to transform primary goods into a good life. And he emphasizes exactly isolated, remote communities, underprivileged communities that are being sucked into the machine of capitalism, whose economic resources are being consumed to produce goods and services directed to developed countries. And it calls all that into question with advanced technologies, such as what we're talking about, to know that these isolated people, those remote communities, vulnerable communities, are they ready to use, and up to what point will it be necessary to provide them with capacity building at the global level? Up to what point this artificial intelligence should be modeled, patterned, and regulated internationally, as Pope Francis would like it to be, with promotion of ethics and human dignity, in order to prevent people from being subjected to an authoritarian mechanism of social exclusion and subjugation or submission of these people and communities to a capitalism that is voracious. I'd say a super industry of the imaginary, a capitalism of surveillance, a capitalism that brings with it those inner wishes of people to a plan of consumerism that turns them, that makes us very vulnerable in a worldwide computer network that works that way. The other day, Fernando Haddad, our economy minister, actually he says artificial intelligence in the international financial market has a bias. It has a bias because it jeopardizes us, the periphery, Latin America, that serves as a source of natural resources so that the big industry of capitalism will function. We've seen critical situations of states, for example, in Latin America, which have chosen biocentrism, and they're not suitable to capitalism, Western capitalism. A criticism by a philosopher, I read it recently in Spain on a certain occasion in Barcelona, in which he said the following: Ecuador needs to decide whether it's Ecuador or Switzerland, because the Constitution is beautiful, it looks nice and dandy, but in practical terms it doesn't work, because there's a lot of semantics, and in fact, without any effectiveness to safeguard individual rights and the rights of excluded communities, as most communities in the country, made up of indigenous peoples and their descendants and peasants, that don't really mirror the reality of capitalism that in fact occurs, and many times they're trampled upon by this machine that calls all of these things into question. But in what ways will we use all that? Without using it, there's no way to navigate this global reality. But I think that the Pope Francis is absolutely right in his concerns and the letter he published with respect to global peace and the use of social media. These modern means of communication and digital transformation to the benefit of human dignity. And in this aspect, I think that some questions have already been answered. Someone is asking about the possibility of artificial intelligence judging people. It's vetoed. It's forbidden to use artificial intelligence to rule over the freedom of people. Human beings cannot be judged by a machine, by artificial intelligence. They must be judged by his peers, by a jury, in a courthouse, a natural judge, and all the guarantees have been designed and written in the Constitution, in the legal system. So the answer is no. There's no possibility whatsoever that people will be judged and sent to jail by an algorithm. Can it be used by judges to judge lawsuits? Will it be used by lawyers? And it is already being used by lawyers. Massively. Artificial intelligence today is able to provide lawyers, if you get a lawsuit, for example, in my office, I can analyze what are my precedents, how I decide, and what's that matter that's decided in my office. Lastly, it offers the lawyer a perspective, the prospect that he can win that case, and guarded actually barring certain situations or circumstances, barring a change in understanding that has to be very explicit. I think that in that sense, artificial intelligence will provide power to predictability, transparency, lack of big surprises, because you start using serial precedents, and the civil process, for example, since the latest reforms, has been adapted to this, the issue of predictability and the massification of the explosion of judicialization. the addition, for example, of statements and verdicts, binding effects, affected matters, all of these things that are pertinent to the common law has been brought within the civil code of Brazil in order to facilitate a better control of jurisdiction in terms of repetition, redundancy, so that won't impose an excessive, a tidal wave of work. A workload won't be increased. Constitutionality controls are more complex, and they must be settled in light of principles and rules, and they have to be weighted against each other, and only the courthouses of the states of Brazil, the state courthouses and the Supreme Court, only they can do it. Not even regional federal courthouses or the Superior Tribunal. They won't judge direct unconstitutionality lawsuits. But they don't rule over the constitutionality of these issues. It's a crucial matter that the judicial branch must solve. Sometimes artificial intelligence doesn't play a significant role in any of that, but in common cases, redundant cases, repetitive cases, yes, indeed. There is a technical question. I'll throw it to Professor Luciano, something that knows the area very well and is concerned and is suggesting, I think that it's a suggestion on how we should proceed, but he asks a question. Pre-trained in public data for tasks that involve the analysis and manipulation of private data. The projects presented by the team of Sao Paulo frame those topics within a closed environment. Professor Luciano, what do you think? Yes, indeed. That is a very technical question. It's known as hagging. It allows us to in addition to training that took place in public data, you're able to work with files that you select, and you can then use these files to increase your capacity, analytical capacity within a specific context in which you're working. The approach that we're using includes this recourse, and this resource is not, it doesn't work for any situation, or it's not efficient to deal with any kind of situation. What we do is, like, we have this possibility, we use it in accordance with the convenience. That's an approach that we have to work always looking towards the best results. We use different models, commercial models as well as open models to large language models. For example, we use all of these versions. Each one of them has a certain feature, and it's suitable to a certain scenario. With generative, active generative AI, we have the possibility of teaching AI and showing it, to show it how it can use different models for situations that are quite specific. All right, Professor, thank you so much. Professor Lauro, about the use of AI by law firms, from a simple lawyer to the big law firms, for this predictive analysis and decisions and tribunals and courts, can it offer benefits to the perfectioning of the system, the judicial system, to improve justice overall? Can it be done? Very well. The fact, I think that Appellate Judge Marcos has already answered it. Law firms are using already the GPT. They're using GPT already, and there are new versions of ChatGPT, which is ChatGPT A4. You pay $20 a month, and it does writes petitions and analyses, initial analyses, and they contest results. They dispute results. It's not flawless, because someone who's looking at analyzing will do this ascertaining or checking, including jurisprudence situations. That's the current state of affairs.
This is already removing from market a lot of trainees and even some lawyers from some law firms. So the PDF file of the initial petition documents are added to the ChatGPT, and it provides you with a complete with a case. Is it the best model? I don't know. What comes out of these new technologies is an almost limitless creativity. It's about getting things right and verifications and having. But at some moment, this has already modified the structure of the law firms, for example. But leaving aside the AI, let's go back to 2022. Before ChatGPT was around, we already were doing some of this. This is normal. This is part of the lawyer profession to verify. This isn't a trend logically, but to know who will be judging your process. That was something that was done. This research was done. This jurisprudence research was done already before. And the system just brings us this. All you need to do is type up the keywords and to learn, or just doing appropriate keyword search. One of the activities of some of these colleges is to teach this tool, which is the search for jurisprudence, for example. But what changes from ChatGPT is its speed. Reliability is really up to the professional, a real-life person. Bill Gates says, I prefer to test ChatGPT. So Bill Gates says that I need to test this. Basically, this is something that this is really for the good, but the lawyer's profession and activity is something that the client itself expects from his lawyer. A minimum of predictability in corporate law or in the big multinationals. There's a survey that the lawyer must fill out and answers what are the percentage of chances of success in certain actions. This is a kind of question that is non-answerable, but these are analyses that with a certain quantity based on this data the system gives us. Every state court has its own open jurisprudence. It's totally open and transparent. So the lawyer with his a token to access, he can access court cases that are not even open. But this is something that seems like it's already a part of our day-to-day. If used in an illicit fashion, illicit in the sense that we've seen this already being observed in certain behavioral roles. In some law firms have used this. Something that U.S. law firms called sham litigation, where you file suit to degrade the image of an opponent or a competitor, but who is now on the other side of the aisle. But the judiciary branch is also aware of this kind of behavior and is monitoring this. But if there is a practice such as this of sham litigation, and if this practice is geared towards obtaining illicit benefits, then on the other side we can observe this as well. Thank you, Professor Lauro. Professor Ana Carla, could we say that the challenges to be overcome in use of AI in the judiciary include integration with existing systems or internal resistance, difficulties to write up the correct question, fears of machines and of technology replacing professionals? Could all of these be challenges or obstacles to adoption of AI? There are quite a few questions rolled up into one. Integration with systems, that's not a technical issue, that's a political issue. Technically, all you need to do is build an API to do the connection, and the National Justice Court has a standard for these connections. At the USP, the connections are integrated to the system, even using the legal standard or using an API. Technically, there's no there's no problem. It's about having the courts accepting. So it's no problem integrating systems. Well, internal resistance now is a different matter. Every innovation process has two opposing groups, which we have the detractors, which are, some are fearful, some fear everything that's new, but then when they get to know, that alleviates them, they're relieved and they support innovation. Others resist anything that is new or innovative. So in any new innovation model, if any kind of difference in innovation, for example, digitalizing something that used to be manual, whether, for example, it's about updating the system or having a different system being used, using or not AI, Gen AI, all of these movements, ways of mixing up the matters, that mixing up what used to be done. So you have to have a culture, you have to work your culture to receive Gen AI, and the best way to limit this resistance in an innovation process. You can never really end resistance fully, because there will always be a few people who will be opposed to innovation. But one of the manners is to provide excellent education, and this state court has been very capable using ESMAT for that. The difficulty of typing up the correct question. Well, if we think about a model of application of the tribunal, if it's about the passive ChatGPT to write up the correct question, to understand what is called prompt engineering, another way of asking the right question, that is a problem, because that in an open model, that is a problem because you need to have the probability close to heart, and you must provide context for this. And to provide context, you have to know how to ask. And even if you ask the right question, a beautiful prompt, there's still varying probabilities. So knowing how to ask is very important to deal with Gen AI. It, by alone, it will not solve the problem of variabilities of results. It will still occur, even if in a lesser form. Fear of machines, well, that's the resistance of the use of technology with Gen AI. There are people who watched Black Mirror, Matrix, Terminator. They watch Terminator and they still believe that there's a technology that is capable of that, which is a general purpose AI. That exists as a possible theoretical model. Perhaps in the future the human being may be able to use it. For thousands of years people wanted to fly and couldn't, and one day they were able to fly. at the hands of Santos Dumont. It could be possible to create a general purpose AI, and that this AI may be able to build its own code. It could perhaps become hostile. In theory, that could be possible. It doesn't exist in practice, but some people believe that it exists, and that if you put it in the judiciary, if you add it to the judiciary, perhaps it could be judged. Your case could be judged in a few days. It's an unfounded fear for now. The story of humankind has always been marked by technologies that replace functions that have been occupied by humans. This is a technology that does not really replace our arms. Remember when we talked about the first industrial revolution, where there were no more
acutes em dia, sem pé de galinha, gente novinha. Vocês estudaram para o vestibular faz pouco tempo. Vocês estudaram as corporações de ofício e a transformação que houve no mundo.
There was a huge transformation worldwide with that first industrial revolution.
Precisa tomar colágeno de manhã. Então, vocês viram o que causou aquilo.
So industrial revolutions did without guilds, for example. People who had a manual production in guilds, they became obsolete with that repetitive work. There was a huge economic and social crisis, sociological crisis in Europe. After that first industrial revolution, the world changed, our laws, and if we look at the reflexes of this on the bourgeois society, the rights to property, rights to family, succession rights, all of that was connected to a huge social transformation that existed. And now we are going through yet another social transformation. AI will do without repetitive work. Are they the non-creative works, Professor? You might ask. Well, Gen AI does that, even some creative activities. What I think that may be occurring to us right now is that humanity has pendular motions. Sometimes we go back to one extremity, then we may go back to another extremity. We could maybe rethink this, starting from the Greek philosophers. We maybe ought to reconsider the basic questions. Who are we? Why are we here? The repetitive work that we do today, does that define us as humans? As human beings? What is a lawyer? What does a lawyer do in the 21st century if there's AI that will build an initial petition in 5 seconds? What's the role of the lawyer? Manage conflict? Pacify society? When I was in law school, a good lawyer was one that really argued verbally. Those were good lawyers. I was taught to litigate. That was the role of a good lawyer, a good litigator. Nowadays, you may have classes regarding this. At my time, that's not. You now have classes on alternative methods, other alternate forms of conflict resolution. So maybe the role of a lawyer may not have the role of building initial petitions. That could be up to AI. So what will the 21st lawyer do in the 21st century? How about a judge? What will he be in the 21st century? A judge, for example. I'm a lawyer, but I'm also a professor. Do you think that the work of a university professor does not change with the use of Gen AI? It has. Google has already transformed a lot of us. Sometimes when we go to class, Google has already done a lot of work about recovering information. How about Gen AI? What do they do with new jurisprudence, with possibilities of mental mind maps of a certain subject? I am a professor of financial law. I'm going to work about public debt, and AI is able to write up in one A4 sheet the whole subject. Well, AI may have done this
Me fala aí uma
superficially?
coisa,
Well,
numa
tell
aula
me
de 50
something.
minutos,
In a
no meio
50-minute
de um programa
class,
que eu já te falar,
at the
dívida
midst of a
pública,
program,
despesa pública,
public debt,
receita
public
pública,
expenses, public revenues,
empréstimo público,
public
leis
loans,
orçamentárias, cada dia da
budgetary
semana um
laws.
tópico para
Every
cobrir
day of
todas
the
as
week, there's a
semanas. Em
different
50
topic to
minutos
cover
eu
the
de aula
week.
falando, vocês
50
ouvindo.
minutes of
O
me
que é que dá
lecturing
para
and
se
you
falar
hearing.
de grandes
What
correntes de
can we
discussão
really
teórica
speak
sobre
of when we're
dívida
talking
pública?
about great theoretical
Percebem que todos nós,
discussions
de alguma forma,
on
estamos
public
sendo
debt?
convidados
Can you
a
notice that
revisitar o
we
que faz
are
de nós
invited to
magistrados,
revisit
o que faz de nós
that which makes us
advogados,
magistrates
o que faz
or
de nós
lawyers
professores,
or
e
professors,
mais, o que faz de
or
nós
even more,
humanos?
what makes of us,
A IA
what
veio
makes us
nos mostrar
human.
que o que nos
AI
faz
has
humano
shown us that what
não
makes us
é o
human
trabalho
is not
repetitivo que fazemos.
repetitive work that we do.
Qual
It's
é a
not the
resposta,
repetitive
então,
work.
professor, o que
So
faz
what
de
is the
nós humanos?
answer
Vamos ler os
for what
clássicos
which
da
makes us
filosofia
human? Let's read
e
the
vamos construir
philosophy
novas
classics.
teorias
Let's
filosóficas,
build new
talvez
philosophical
reencontrar o que há de
theories.
humano no outro.
Perhaps why
Talvez
not
reencontrar
resignify
o que há de
what is
positivo
human
que
in us and in
possamos fazer no
others,
contexto
what is
social.
positive in terms of a social
Talvez nos
context.
olharmos que há tanto tempo não
Look at
temos
us,
tempo de
look
fazer isso.
inward
Quantos
to us.
magistrados que estão aqui
How many
chegam em
magistrates
casa,
who are
levam os
here
processos pra
sometimes
casa e não
go
olham para a
home,
esposa e
look
pros
at their
filhos?
court cases that they take home,
Quantos de
and they
nós,
don't look at their
servidores da
kids?
justiça,
How
não
many of
estamos
us
tendo
public
tempo de ver os
servants
nossos filhos
have
crescerem?
time to see our kids grow
Muitas
up?
vezes temos de achar o tempo para
Oftentimes we
levá-los
may
para
have
os
to find
psicólogos,
time to take them
porque
to the
faltou a nossa presença
psychologist
emocional.
because we didn't have emotional presence.
Quantos de nós não temos tempo
How
de
many of
compartilhar
us
com os
are
nossos
out of
companheiros
time
sonhos,
to share
desejos, vontades?
with our
Tem
colleagues
pessoas que pregam um
dreams,
mundo de
desires?
IA muito ruim,
There are people
mundo de
who
IA em que o homem se
think that the
subjuga
AI
mais,
is a horrible
mundo de IA em
world
que o homem é dominado,
where
os processos
AI,
são
where
feitos
man
todos
is
por máquina.
dominated
Se
by
deixarmos,
AI.
podemos criar um mundo desse.
If we allow it,
Nós podemos
perhaps a
criar um
world
mundo
like
desse,
this
porque a
could be
tecnologia
created
permite
because
isso.
technology
Eu
does
sonho com
allow
um
that.
mundo de IA que devolva
But
o meu
I
tempo de ser humano.
But I dream of an
De
AI
ser
world
humano,
where I can
descobrir
have free
de
time
novo o que é
again,
isso.
which will return me
É
my
uma
free
tentativa que eu penso que
time
todos nós
and which
temos de
allow
fazer.
me to
Então, eu não
signify
tenho medo
myself as
da
a human
inteligência
being.
artificial
So I am
generativa no
not
poder judiciário, nem
afraid
como
of Gen
advogada,
AI
nem como
in
cidadã.
the judicial court
Tenho
system,
medo
neither
de
as a
perdermos a
servant
nossa
nor as a
humanidade,
citizen. I
emaranhando
am
num
sometimes
mundo de
afraid of
processos que
perhaps
não conseguimos
missing
sair,
out on
porque
our
é humanamente
humanity
impossível
because
sair.
we are mired in
Esse é
so
o mundo de
many
IA que eu desejo no
tasks
judiciário.
that were impossible, that it's impossible for us to see anything outside our work. That's what I desire for the AI, for AI.
Olha, eu devo dizer, essa história aí eu sei de cor.
I know by heart this story.
Em Tocantins,
Um,
utilizar no judiciário. Eu fui
I was
praticamente
practically
perseguido pelo Tribunal de Justiça porque eu utilizava tecnologia.
I was persecuted by my state court because I used technology. When I had one of the first computers in state court, immediately afterwards I purchased a notebook or laptop computer. It was at that time it was rare, but there was someone who was selling this to me, a Japanese notebook. Its hard drive had 40 megabytes of storage. It was a Nova branded notebook, and I had a portable printer as well. So sometimes we had to do some missions outside. I'd take the computer, I would print out on my form printer. In Auditorium in Tocantins in 1992, we worked there. We used a spreadsheet. Many don't even know what it was. It was called Lotus 123. That you could program a spreadsheet just as today you do that with Excel. And we built our first intelligent election map in the country. Then that was sent in a form to the electoral courts. That's probably still around, one of those reports. That was the first time that we used an electronic system to automatically total votes without having other problems of... It took us an hour and 40 minutes to deliver the results of the elections, and afterwards I used it again in another activity in Tocantins, even before any system of the Superior Electoral Court was implemented. But the tribunal did not allow us to use. So the way I use it, the TSC would not accept it. I needed to withstand pressures, but 1995, finally the tribunal accepted it.
Appellate judges would harass me. The first vote at the courthouse produced on a computer, and he showed it at the session, the continuous forum, saying that it was the first vote, digital vote. Well, what a big victory, what a huge achievement. And there was APAC too. There was no internet in Brazil at the time, so we communicated via APAC to go into the upper courts. You had to read a manual about 300 pages, and you had to know it by heart, all the codes, to be able to go in there. And it was a white phosphorus monitor, and then green, and then the white. And when we got Windows 3.1 in Brazil, 1996, 97, then we got the colored phosphorus. Oh, wow. With all those games, but what the big impact for me was FIFA 2017. What was that with the narration, live narration, and the noise from the pitch and the bleachers, and the noise on the songs and the narration, and the tactical game that you would have to play to face the adversaries, and there was a band, and there was a little delay, and there was a handicap that you were winning 3-0 at the end. You started losing. The player wouldn't get to the ball, and your adversary was artificial intelligence, and they used algorithms to make the game more even, and you ended up at a tie or losing the game. It was quite frustrating. So I hope that it will improve, but I stopped playing the FIFA game, just the young kids. That's quite addictive. I don't recommend it to you. It's quite addictive anyway. I have one last question. It vanished from my screen. Well, can you open it for me, please? Help me out. Just one more question for Professor Luciano. I think it's interesting. It's about the documentation implementation process. When we go to the next phase, I will announce that the ours project has been selected by Exponential Judiciary as a benchmark project nationwide, and we should be getting some recommendations or compliments from Brasilia on the 15th and 16th. I want to tell you that we just got wind of that right now, and we're so happy. I just received on my WhatsApp that statement. It's within the greatest national innovative projects in the judiciary branch that can provide a better quality of justice being delivered. Okay. Professor Luciano, it's about the modulation models for these court cases. How are you doing the control? You're going to do the control of the annotations and notes and all that, and the checking of all that as scientific standard to carry out validation to ensure that the model will be validated once we start implementing and using it in our offices. There are some approaches to deal with court cases. Translating it in simple terms, how do you teach the computer to follow a flow, analyze those spaces to see if they've all been fulfilled or not, and to record what happened? There are some approaches. Some approaches are more open, others are more difficult to do a representation, a valid representation, and the project, what we have used Okay, fine.
modulação dos processos
Modulation
do
of
tribunal é
court
realizada
cases and the
quando é
tribunals is
utilizado o
done.
business
How is it
process
done? You use the
BPMN.
BPMN.
Essa é uma
This
abordagem
is an approach,
BPMN,
BPNM
que é bastante
is an approach
utilizada, é
that's
uma
frequently
notação
used.
para
It's
você
annotations for
representar
you to
fluxo.
represent a flow.
Já uns desenhos,
So you have the
padrões,
drawings and
você
patterns
segue,
and how
se
you
você
follow
marcou o
follow
resultado
if you
X,
got the
segue
result
por
that you
caminho.
wanted. You
A gente
you
tem
will
usado
follow a
outra
certain
abordagem,
route.
porque uma
We've
das
used a different
limitações
approach.
é a
One of the
validação
limitations is the validation,
automática
automatic
desses fluxos.
validation of
Então,
those
a gente usa
flows. We use
outro
another
arcabouço
kind of
teórico,
framework,
que se
theoretical
chama
framework
álgebra de
that's called
processo, que
process
permite,
algebra
então,
that
a
allows us to
validação.
validate.
Ele tem uma
It
representação
has a
formal,
formal
então uma
representation
validação
that
de
provides
corretude
validation
desses
of correctness of those
então, ou seja, essa é uma
steps.
resposta
It's a
técnica
technical
dirige ao
answer,
Tribunal
and
Superior.
while I'm
Então,
done
é
with the
outro
technical answer, it's a
processo para dar
different
ainda mais
process
poder de
to
validação automática
to
desse
ensure
processo.
even more
E o que o
validation
desembargador
power to this
colocou é
process.
que cada
And what
desses
appellate judge
passos ele gera
said was each one of these steps will generate
registro do
a
que
record of
aconteceu,
what went
se
on,
aquilo
whether
seguiu
that followed a
um
certain
encaminhamento da IASA ou
route by
alteração de
IA, if
plano,
there
se ele
was
teve intervenção, isso
interventions
fica
by
registrado
humans, and
para
that's
um
recorded
acompanhamento.
for
A
follow-up purposes. The
rastreabilidade e a
traceability and the auditing
são
are
itens
items that are
essenciais
essential
dentro desse processo.
within
Por isso,
this
desde o início,
process.
a
That's
gente
why from the
pensa
very
nessa
beginning we think
possibilidade.
of this
Quando a gente está
possibility.
trabalhando
When we're
com
working
chat, uma
with
IA
chat,
passiva,
a
é
passive
difícil fazer esse
AI, it's
acompanhamento. A pessoa
difficult to
manda
do the
prompt,
follow-up.
manda
The
outro,
person will
corrige,
send a
mexe,
prompt, another
volta,
one,
copia,
they'll
abre um
correct, fiddle
Word,
around, and will
e lá
copy and
continua
open a new
trabalhando.
Word
Então,
document.
pouco,
So it's a bit,
você não consegue
you're not
acompanhar o que
able to
está
follow what's
acontecendo.
going
Nesse
on.
processo, não.
In this
Você
process,
vê
however,
o
you
passo a
see
acontecer
the
e é
step-by-step
registrado,
that's
permitindo
recorded,
essa rastreabilidade
and
e
it allows for
o
traceability and the
acompanhamento de
follow-up
diferentes
from different perspectives. Thank you.
Muito grato pelo esclarecimento.
Thank you very much, Professor Luciano. This was a very elucidative technical panel, very enlightening, a discussion that's very deepened on a topic that is so current with direct impacts on human rights. As we have seen, we think that artificial intelligence will lead to a state of affairs that's unconstitutional, but it will also be able to combat a state of unconstitutional matters by helping human intelligence with the amplification of its capacity to obtain results and produce new ideas and manage public policies, generate public policies and initiatives at the level of government and the private sector too, as well as mechanisms that will improve the lives of people. I'll give you an example. I made that comment in New York, and to Google Cloud people, the development of the tool for mapping, global mapping, to monitor deforestation on top of Google Earth project that was created specifically to be able to allow us to map out the global the planet Earth. Actually, this tool allows us to have a view of 30 by 30, something that would have been impossible, unimaginable a short while ago. So today it is possible to have this interaction, and there are several institutions taking part in this process, such as the Accounts Office Court of the Union and other fora and NGOs discussing the mapping of the Amazon through artificial intelligence resources that are available, and this LIDAR project too by the University of San Diego in California, which now is able to map out all of the archaeological remnants of the Mayan civilization in Central America through the use of laser mapping. The same a Pro iPhone, the latest generation iPhone, you can map out 3D objects. You can remove the forest and you see only the remnants, the archaeological remains, and unearthing important information about the past and the history of mankind And each day, each and every day, the technology is improving. It's increasing our knowledge. And they answer questions that mankind will use to improve the lives of people, and it increases interest in areas of knowledge and scientific research, and it's a matter of support. It provides support. And I have contacts at the United Nations. Professor George Andropoulos talked about the role of the UN vis-a-vis its activities in the Security Council against genocide and related crimes. But another side of the United Nations is this dialogue, interconnection with the use of technologies. There is an advanced study on smart cities at the United Nations, the use of artificial intelligence, the use of mechanisms for people to solve their problems more quickly, and the prospect of improving the lives of people. Interestingly, with an emphasis on human dignity above all. And what do they have today? Artificial intelligence must be a tool an assistant, to provide assistance. And in the judicial branch, we're ready for that with regulation. Professor Lauro has talked about something very interesting, the watermark. I proposed in New York to Minister Cuevas, the president of the Commission in the Senate, that when you use AI to produce any piece, there should be a footnote that IA was used. You don't have to tell people whether it was active or passive, so that the party will be aware of the use of that tool as support in the production of that piece. Obviously, we're not going to use artificial intelligence to produce the whole piece. And in the tool that we're developing, one of the requirements is the following. We're going to do a predictive analysis. We have a prospect of decision-making prospect, but first of all, there's the possibility of you asking, for example, so that artificial intelligence will help you map out those points, controversial points, the sensitive points of the request, and present suggestions of decisions in many areas, for and against, and you will be analyzing it and the foundations that were presented before. This is good and this is better, but it needs to be deepened. We have to go deeper. And she can actually establish a dialogue with the tool, and you will develop your reasoning, your rationale, and you will ask the tool to help you develop your own reasoning, acting as though it were a writing assistant. It will only present a minute of a suggestion of a decision, of a verdict, if you send the command asking it to do it. It's not automatic. And you have to have this traceability, this auditing and transparency, as we've seen here, document by document. It's a human being ascertaining the service that the machine did. That's what really provides security and allows us to actually wipe out any doubts we might have. Again, thank you all for participating in this wonderful panel, mostly our professors from Sao Paulo, who have showered us with their expertise. The University of São Paulo and FADISP have actually added a note of brightness and brilliance to this panel, which is a watershed in the history of the judicial branch of Tocantins. I'll give the floor back to the Master of Ceremonies for the closing session of our Congress. Again, thank you to all the panelists, Dr. Ana Carla, Dr. Liziane, and Dr. Lauro, and a note of thanks to the coordination by Marcos Villas-Boas, the coordinator. I would like to invite you to provide our panelists with certificates. Group picture, please. A picture of everybody. Can you? Thank you very much. I will now invite you to remain on stage because we'll have an award ceremony. You're very anxious. The students are very anxious. We're going to have now a moment of the awarding of prizes to the banners. We have banners out there in the lobby, and we're very happy to announce, first of all, in the professional category, graduate work, third place. Study on the methodology, approach, law and public policies, improving the effectiveness of government interventions through the application of law by student Naima Vaughan. Is she there? Is she with us? And the mentor is Marcílio Toscano Franca Filho. Are you in the audience? You're not. Anyway, let's go to the second place. Second place, we have a title, A Debate on the Disinformation and the Right to Information Based on the Concept of Semi-Information by Theodore Adorno, by professional Wesley Pereira de Souza, and his mentor is Professor Paulo Sérgio Gomes Soares. Is the professor there in the audience? Please, if you will come up and to get the award, sir. I will call on the first prize title, Quilombola and Territorial Rights, Audrey Bentis Pontes. First place, please, if you will join us on stage. Thank you very much. Let's take a group picture. Everyone, please, group picture. Very well. A round of applause for our laureates. And now we're going to move to the category graduate students, male and female students, third place. Eternal absence, the case of Laura Victoria, and the disappearance of children and teenagers in the state of Tocantins. Liza Victoria Guerra Araújo and Lucas Abelardo Zorzi. Mentor Audrin Benches Ponches. Please come back on stage, all you guys. Come back on stage, please. I would like also to invite on stage the laureates, second place, under the title Criminal Fires, Penal Responsibility of Culprits and the Legal Protection of Brazilian Forests, Bruna Gonçalves Stelita and Ana Júlia Coelho Flores. Mentor, Professor Dr. Tarsis Barreto Oliveira. Please, if you will join us on stage. Thank you. And number one, first prize, first place, actually. Just a second. Eu pedi para Let's take a picture. They deserve a round of applause. Thank you very much. And now, first place, you're very anxious, I'm sure. Transphobia, the activity of the state court system of Tocantins related to the prevention and fight against transphobia. Felipe Milomes, Paulo Pávia, Maria Clara Rezende, Duarte Queiroz, and Marcela Castro Pugliese Reis. Mentor, appellate judge Angela Isa Rauna and Liziane Pajão Silva Oliveira.
Men. They deserve a warm round of applause. Thank you very much. Ladies and gentlemen, now we will have the raffle. We will raffle 3 books. One of them is Cyber Resiliency, Mini Strategies of Security, and AIs, Generative AIs. The authors are here on stage. So let's raffle them. Vivian Duarte Mota, is she around? No. Mayra Simone Ribeiro Pereira? Nope. Antônio José Ferreira de Rezende? Beatriz Rocha Cavalcante? Eugênia Paula Meirelles Machado? Tarcísio Bara Carvalho? Luiz Felipe Franco Chagas da Mata? Next name. Next one. Jaqueline dos Santos. Nope. Next. Nope. Last book. Carlos Henriques Alves de Almeida. Jeová Cardoso Júnior. Nope. Nope. Next. Camila Menezes Maciel. Jennifer Carvalho Marques. Carlos Gomes Quintana Gonçalves. Oh, he's around. There we go.
Olha, eu vou ter de romper aqui o protocolo.
I'll have to break
dizer da nossa
protocol
alegria de
and
entregar
say
esse
how
livro que
happy we
colega
are
nosso do Fofo
to
fez
deliver,
conosco o
to
curso
give
do
this
Fofo
book
mais mate.
to a colleague of ours. We thank Pousado Gerações, a STJ, for the gifts given for our. We would now like to wrap this up by invite our residents of the Legal Residents Tocantins Justice Program. They prepare young graduates and undergraduates to help magistrates. We'd like to invite you for an official photograph. Cara, anyone else? No? Please join our dear appellate court judge, and everyone smile for the photograph. Just say the name cheese, Tocantins cheese, Tocantins. So we thank you all very much. I would now like to thank our friends who are watching us live on social media platforms. Ladies and gentlemen, it's an honor for ISMAT and for UFT to end the 17th International Congress on Human Rights. In this edition, we highlighted the importance of an interdisciplinary dialogue and international cooperation in the search for innovative solutions for the common and modern challenges on human rights. This event joined together academics, professionals from different countries. We reinforced the commitment to building a more just and inclusive society. The speakers and their content, the professors such as Moracio Lopes, Nuno Miguel, and Igreja Mata, their example inspire us to continue promoting debate and actions that will encourage human dignity. We end this Congress with a conviction that the search for social justice protection and human rights protection depend on our joint work. We thank you all, and we'll see you next year. Thank you.